Wait, please. Look, so far as the constitutional scheme emerging from the conjoint reading of entry 54 list 1 and entry 23 and 50 of list 2 is concerned, Lord, Mr. Salve has already taken your lordship from Lord Hingir Rampur till Kesav Ram judgment, my lord, which I'll not, my lord, dwell much upon, my lord, except for 10 minutes, just a brief overview. But, my lord, I would.
Yes.
I'm sorry, my lord, very much. But I would like to place before your lordships the government's perspective, my lord, why the architecture of the MMDR Act is the way it is and how it impacts the power of the state versus power of the center. But before I do that, my lord, I want to make one thing very, very clear, my lord. Because the impression, my lord, which is unintentionally gathered is this, that this is kind of a federal issue between center and the state and who has the legislative competence to levy. At the outset, I say that is not the question here. Right? Lord, here, and as my lord, I will explain, my lord, in a little more detail with some facts, figures, and statistics.
Which volume was it? Yes.
Lord, the way, my lord, MMDRA works, and it is intended to work as a limitation, is this, my lord. It is not a fact in dispute that the mineral rights and the ownership of mineral waste with the states, and therefore every penny of royalty goes to the state government. My lord, if your lordship would not like to, my lord, write down, my lord, I have the propositions also, my lord. At the end, my lord, I can give the propositions.
Yes.
But just, my lord, to make it more convenient for your lordship, my lord.
Yes.
Lord, every penny goes. The state government grants the lease. The lease deed format is provided in the central statute.
Yes.
The state government collects the royalty. The royalty figure is fixed by the central government. The state government appropriates that royalty amount with other amounts which I will show as a part of its consolidated fund.
Yes.
So these are not the facts which are in dispute or which can be in dispute.
Yes.
Now, my lord, why the center discharges the function of only fixing the rate of royalty qua each mineral? There are several factors, my lord, which I will show, but broadly, to ensure uniformity in the price structure throughout the country,
Yes.
and my lord, our domestic price structure will have to take into consideration two factors. I'm just giving a broad overview. One, the domestic requirement. Which can only be decided at the central level. And second, since the royalty has a direct nexus with the price of each mineral, we will have to be very, very careful and conscious about the global market qua that mineral. If that mineral is cheaper somewhere else, people would start importing Indian domestic users and vice versa. So it directly impacts the import export. I may not go into the details. Good. Next and the most important thing, as I would show, my lord, from one report, which is report prepared, my lord, every 3 years. Your lordships are aware, Section 9 provides that the royalty will, the rates of royalty would be changed every 3 years. So, my lord, there is a report prepared. My lord, it was really heartening to know
Yes.
a classic example of cooperative and collaborative federalism. What the central government does, your lordship did not write, Lord, in my note, your lordship would find everything. We call for the views from all stakeholders. Stakeholders would mean industries, stakeholder would mean people who are going to be affected by the industries, because ultimately we have to protect the environment as well. And essentially, and more importantly, the state governments. I'll show, my lord, from the last report of 2019 that the state very effectively involved in the process. They say that this particular mineral, bauxite, please increase it by 2% because this is our revenue generation. These are the reasons why it should be something more. Then, I'm sorry. Then the subgroup, after receiving, my lord, all these detailed inputs, examines what are the global scenario, what will be the impact on the export-import. But all these minerals are required for the core industrial sector of the domestic market. That is taken into consideration. The core industrial sector is the heartbeat of any economy. So that is considered, and I will show that to your lordships. And thereafter, with reasons why the state's request is either accepted or not accepted, my lord, a price is fixed qua each mineral, and thereafter the central government is out of it. Now you collect, you appropriate, you do whatever welfare activities you want to do in your state. The only dispute between the parties, my lord, in these proceedings is, after having, my lord, it is our case that when we decide the amount of royalty, the figure of royalty, that is all inclusive, taking into consideration all your requirements. What the states say, that over and above the royalty, we can independently levy certain amount under various names. What we believe and what, my lord, the Act perceives, the objective of the Act is that and, my lord, whatever I am saying, my lord, I'll be able to make good from, my lord, the record. So suppose iron ore or bauxite, some amount is fixed, say 100 rupee per ton or per whatever, my lord, there are, my lord, pit's mouth value, etc. That also was argued, but I'll show that's not relevant for this purpose. So the amount comes to say 1,000 per ton, giving a absolutely hypothetical example. They say that every state will have a power to levy something more than 100, more than 1,000. We say no, it is all inclusive. And the reason is this. If every state start imposing further levy, in some case it would be 1,500 per ton. In some case it would be only 1,000 per ton. In some state it would be 1,100 per ton. The uniformity of the prices will not be maintained. And I want to flag, my lord, that issue before, my lord, I take your lordships to this, my lord.
Mr. Solicitor, as you are formulating your thoughts, and you have given the example of bauxite, and you say that this rate that is determined, and you said that this is done after elaborate consultation with the stakeholders, including state. And then you say the state is trying to extract over and above the all-inclusive price which you are suggesting to us.
Correct.
Now, taking a cue from the example of bauxite, have you not boxed in the state so far as exercise of their power under 50, entry 50 list 2?
I could not understand the last.
You see, I've said that you have boxed in everything. So, where does the state have the power to exercise under entry 50, their power of tax?
That's my lord, respectful submission that the entire architecture of MMRDA, under which this box price inclusive of everything is fixed, is a limitation on the state's legislative power under 50.
But it's totally denuded, you see.
That's my respectful submission.
No, correct.
But otherwise, I'll just give an example, my lord, my lord, why this creates a problem.
Why should the, I mean, just asking, of course, you are just on the starting point.
Yes, my lord.
Why should the act, the statute, not say that this is what the tax that the union is charging, and to this extent the power is denuded or something to that effect? Why are we asked to read this by inference?
My lord, legal submission would be different, my lord.
We also have the situation of, I mean, I was just discussing Article 265.
I'm merely fixing the role.
That's one which will be forthcoming.
It is there. It is there, my lord. It's invalid text, my lord. Invalid. It would be unconstitutional. But Lord, I'll be able to show that there is an inbuilt statutory mechanism which says that this amount and nothing more. Otherwise, my lord, what happens? Just give. Of course, example would not, my lord, be the basis for your lordships to decide. But I'm just giving an example, the rationale why, my lord, this is under the central control. The fixation. Lord, suppose there are two states, A and B. A has, my lord, an electricity generation station of a huge capacity. They are using coal as a raw material. B has raw material mines, my lord, namely the coal mines. They say that over and above 1,000 rupee, which is the royalty fixed by the central government, I'll give examples. In many states, pre-Lord India segments, other cess, education cess, different nomenclature, was 300% royalty, 500% royalty, etc., etc. So that state A having the electricity generation plant will have to either pay more from state B, because every state has a different price structures.
But Mr. Solicitor, that is implicit in the federal scheme. You see, therefore, unless you say that, look, when you fix, as you call it, an all-inclusive royalty, that royalty includes all taxes also that can be levied by the state. You have to go as far as to establish that.
Correct, Manoj.
That the fixation of royalty is itself inclusive of all taxes, state
and
taxes.
Nothing more.
That's one. Second, your argument that, well, it's desirable that there should be uniformity of the price of minerals. It may be a desirable argument. It may be a desirable matter as a matter of policy. Question is whether this will impinge upon the federal distribution of power under the Constitution. Now, take another case. Look at, there's several taxes the states can levy under the state list.
My lords.
I'll just give you two examples. Entry 53 of list 2, taxes on the consumption or sale of electricity. Right? Now, in various industries, electricity is not just a medium, but it's a raw material. For instance, in the production of steel, iron and steel industry, electricity itself is a raw material.
Yeah.
You know,
It's part of the price structure also.
right. And now the constitution contemplates that each individual state can levy a tax on the consumption and sale of electricity. Now, different states levying taxes at a different rate on the consumption and sale of electricity will meet with the same argument that you are urging, that in Maharashtra may impose it at a different rate, Karnataka may do it at a different rate, a solar plant in Rajasthan may do it at a different rate. But that's part of the federal scheme. Or take entry 54,
Right.
taxes on sale of petroleum crude, high-speed diesel. High-speed diesel is crucial for industry, motor spirit, natural gas. So if you are consuming natural gas from, say, which comes in from Jamnagar, different rate altogether. If you are importing natural gas, which has come in through, say, a crude pipeline, a gas pipeline, say, in Chennai, completely different rate. That's exactly the scheme of the constitution. That and there is nothing sui generis about minerals, that there should be a uniformity. Then the same logic will apply to electricity. Have the same rate of electricity, same taxes for electricity.
Ignore that example and I'll give the answer. I'll give the answer. In other entries like electricity or entry 54 list 2, there is no provision like entry 50 that's subject to limitations placed by the parliament under 54.
But therefore,
That
there is a
makes-
safeguard. Suppose, say Jharkhand places taxes at the rate of 500%.
My lord, ignore that example. My lord, I'll make it good on other issues.
Suppose some state levies rates at the rate of, say, 300%, something disproportionate, which will really affect the industry. And that state is the primary source of that mineral in India. Parliament can certainly regulate the rates. When you are prescribing limitations, you can say that, look, rates will not exceed so and so. Rates on this mineral will not exceed so and so. You can have differing limitations for differing minerals.
My lord,
So,
please ignore
Parliament-
that example for the time being.
Union has not thought through how they can use the limitation power, imposing power, to ensure that where the states are not restricted in imposing taxes, the taxation structure in the states does not affect overall the development of the mineral or the development of the industry. Parliament can still do it. But they'll have to do it then in a nuanced case by case, mineral by mineral basis.
My lord, that is where, my lord, we would respectfully, my lord, argue that MMRDA is that restriction, what is the constitution says, limitation on. Well, this is sui generis for the simple reason. This is the only entry, taxing entry, which is made subject to some other entry. There is no other taxing entry, number one. Number two, in
But it's
case
not
of...
made subject to the other entry. It's made to subject to limitation in the interests of regulation and development of minerals. So it's quantified very carefully. Mr. Solicitor, if you want to sit for a minute, sit.
No,
for a
no,
minute.
I'm
The limitation is a constitutional limitation. It is not any kind of limitation.
exactly.
So a constitutional limitation has to be read in the context of Article 265 of the
And
Constitution.
that too in public interest.
Because there can be no taxation except
Correct.
with authority of law. So a constitutional limitation to tax juxtaposed with Article 265 must be the
Correct, my lord. I bow down. I bow down.
interpretation.
I bow down. My lord, second, as my lord, I
I think you have to answer.
Constitution.
You are banking upon the fact that states have say in determining royalty. There you may not be right. Under section 9 subsection 3, it is the exclusive power of the central government to decide what is the royalty.
my lord, can I?
States have no power, no read section 9 subsection,
My
the
lord,
exclusive domain of the central government. States do not have any say in fixing royalty.
my lord, if your lordships can, my lord, consider, my lord, allowing me to develop further.
You are just pointing out so that you can answer.
Certainly, my lord. I'm conscious of the fact that the consultation is not statutorily contemplated.
That's
That's what, my lords are very rightly putting it to me. But the consultation is read in every provision. That's what I'm going to show. My lord, please take my written submissions, my lord.
Where do we get them, Mr. Solicitor?
My lord, volume 2F. And my lord, I will ignore whatever is argued or whatever may perhaps not be relevant immediately.
Volume?
2A.
2F.
It should be
2F, my lord.
E.
No, it is thereafter changed. There was some mistake at night, my lord, like,
We should ignore E.
yes, my lord, please ignore it, my lord,
Okay.
and if possible, delete it, if it is possible to delete. Annexure was wrong, my lord. Instead of the report of 2019, the report of 90 was annexed. There was nothing to hide in there, but that was no relevance of that.
Got it, got it.
Page 5, my lord, page 4. PDF 5, I'm sorry. PDF 4. my lords. I'll, my lords, keep what is not relevant, but what is relevant, please allow me to, my lord, read. My lord, this history relates back to the industrial policy. I'm not reading it. I'll just, I have annexed, my lord. Lord, Lord, historically, Lord, immediately, not immediately, but sometime after independence, Lord, we declared our industrial policy, Lord. First was 48 and thereafter 56. I have annexed it for your lordship's reference and record, but I'm not going to read it. Lord, the intention to place this is this, Lord, that the nation for the first time decided how our industrial growth will take place, what would be the roadmap. And there, they divided certain sectors in Schedule A, Schedule B, Schedule C, and Schedule D, where core minerals were placed in Schedule A because they are directly or indirectly responsible for industrial growth of other industries. That's the purpose. Lord, please come to Lord, PDF 6, Lord. Para 4. PDF 5, Lord, I'm sorry. PDF 5, Para 4. I'm sorry. Okay, this is wrong. I'm sorry. Lord, PDF 6, Lord, I am, as usual, Lord, behind the rest. Para 4, Lord. The Industrial Policy Resolution 1956 put major minerals such as coal, lignite, mineral oils, iron ore, copper, zinc, atomic minerals, etc. in Schedule A, which was reserved exclusively for public sector, and minor minerals in Schedule B, which the private sector was allowed to participate in mining activities. Your Lordships can, my lord, thereafter come to page 5, para 5. The minerals available in the nation are naturally finite and are perhaps the most valuable resource for the development of the country. Minerals are the vital raw material for the core sectors of the economy. The exploration, extraction, and management of minerals have to be guided by national goals and perspectives to be integrated into an overall strategy of country's economic development. The endeavor shall be to promote domestic industry and reduce import dependency, which make domestic industry resilient and self-sustainable. Well, this is the difference. In other cases like electricity, etc., we don't have to see the global market. There can be, my lord. And please, my lord, for the time being, my lord, allow me to say, please don't treat this as a federal issue. There is no state versus center. It is the state government which collects everything only for the reasons which will follow. The price, the royalty fixation, the quantification is done by the center, keeping the global phenomena and the domestic scenario in mind. Then your lordships may come to my lord 7, para 8. This is, my lord, more relevant, my lord, why, to answer, my lord, the Chief Justice of India's query, my lord, why mineral stands on a different footing and why its fixation of everything which is to be extracted from whoever is liable to pay is to be federally governed, my lord, if I may use that expression. 8. The mining sector and extraction of mineral, by the very nature of the subject, requires to be taken up holistically at a national level, as its regulation and development shall have to be based upon the following. My lord, please see each one of them, my lord, carefully. National landscape for protection, exploration and extraction of mining. Mineral being a national wealth, its distribution for the benefit of every citizen of each state as per principles of socialism enshrined in the preamble. Then 3, impact of high burden of levy on Indian minerals in comparison to international mining jurisdiction. Look, this is crucial. Look, if high burden is put on each mineral, my lord, by different states differently, we may not be able to, my lord, deal with the global situation. Lord, 4 is really, my lord, crucial, according to me. I'm sorry. Lord, your lordships, when examines, my lord, interpret the entries or any constitutional principle, the lordship would examine, lord, would keep in mind these factors because these are in public interest as envisaged under 54. But let me, my lord, proceed, my lord, rather than, my lord, para 4. My lord,
Parliament can always say, by prescribing limitations, apropos your submission, we understand the policy issue in the submission, but Parliament can always say that, look, the carrying cost of this particular mineral should not exceed a certain amount. So then you can indirectly ensure that the
Lord, that
tax
is said,
structure
Lord, if
also
your
doesn't go out of hand.
Lord, that is said. That is said, I want to show that. If your lordships can, my lord, just bear with me for some time. I'm just giving the justification for it. And, my lord, this is my answer that the architecture itself is a limitation. Please see, my lord, 4. And this is, my lord, really crucial for the nation. Dependence of, and for the time being, your lordships may, my lord, consider, put, my lord, these 2 entries on the side. Just examine, my lord, the bare situation, my lord, which the country is dealing with. And thereafter, I'll come to 2 entries and how the law has taken care of. Dependence of imports for certain minerals and regulation of exports of domestic minerals, use of which is needed for the core domestic industries. Now, please note this, my lord. The import and export is mostly based upon the comparative price fixation in domestic as well as global market. And such price fixation shall depend upon the levy of royalty and others imposed on each mineral in India. Lord, meaning thereby, if we overtax a particular mineral, my lord, suppose some mineral is, my lord, available only in 2 states, it is overtaxed. then the domestic industry in rest of the India would go for importing the cheaper mineral from the other countries. This has a direct national impact. Then 5. The national concern about growth of mineral sector at a national level so as to ensure that share of mineral industry contributes in the country's GDP. But when we say that we have a law for regulation and development of mines and minerals, we also mean that we want it to regulate and develop in such a fashion that it contributes to the GDP as a sector, not state-wise. Then 6, the fixation of consolidated amount like royalty, etc., at a national level for each mineral will ensure availability of domestic mineral at a reasonable price as compared to international prices. Separate levy regime by mineral-rich states results into disparity and high cost of domestic production, leading to closure of mines, necessitating import of cheaper mineral from global market. Fixation of the total levy on minerals in such a manner that not only the concern of all mineral-rich, but the concerns of mineral-deficient states are also taken care of, because the industries would be situated, core industries, which are using these minerals in other non-mineral states. So they get one particular mineral at one particular price and they don't start importing, or if some state decreases the royalty, they can even start exporting. I can face the contention that you remove you stop the export, but MMRDA is a one-time solution. That no, we will fix everything. So there is no difficulty in domestic production, domestic pricing vis-a-vis global pricing. Then 9.
Just as you're fixing the rate of royalty, is it not possible, as the learned Chief Justice said, to have a ceiling or fix a rate of tax? The power to tax is with the states.
That is there.
But you can have a rate of tax or a ceiling on the tax to have uniformity with regard to taxes also.
Constitutionally, it's going to be my submission that under entry 50, it says tax on mines and minerals subject to limitations imposed. This is the only entry where taxing power is denuded by the central law for mines and minerals if it is in public interest. The judicial inquiry would be, while examining entry 50, whether this is a tax by the state? Yes. Whether there is a law made by Parliament under entry 54 list 1 for regulation and development of minerals, and I'll show all this comes within development and regulation of minerals. And third, whether that law of Parliament is contrary to federal structure or is in public interest. I'm showing public interest right now. Now, 8, to bring in uniformity in the structure of regulation and development of minerals and other aspects so as to make it an investor-friendly regime, incentivizing more investment in that mineral sector while balancing environmental concern as a holistic national level. The development of mineral industry needs uniformity at a national level, failing which fragmented state-wise levy will adversely impact the development of minerals and systemic utilization of minerals in larger public interest. The moment there is an act under entry 54 regulating and providing for development of minerals, that puts a limitation on the taxing power, apart from the specific limitation which I'll show. But my first respectful submission is that the architecture of the MMDRA, the rules framed thereunder, and the statutory formats in K, specimen K, not specimen, form K, Mr. Salve read one part of it, but I will read the other part of it, which specifically says that you are being given lease. What is lease? Mineral is a national resource. It's owned by the people. Government is only a custodian, a trustee. In 5-judge bench, your lordships have accepted this principle regarding natural resources, etc. What we are giving by way of a lease, we means the state, right to extract, sell and appropriate the sale proceeds of something which is a national resource. In consideration of that, what is paid is royalty. And my lord, the way my lord, Form K is my lord, couched says that this, and nothing else. Royalty, rent, dead rent, and rent, nothing else. That's my lord, the statutory contract one enters into when one takes the privilege of sharing the national wealth and appropriating it, my lord, for commercial use, which is also necessary, my lord. I am not opposing, my lord, that concept. Now, your lordship, my lord, kindly come to para 12, 8 means 9, PDF 9, my lords. My lord, I am skipping what is not necessary, my lord.
There is one thing.
My lords.
You may not skip,
My
Mr.
lords.
Solicitor General. Come to para 9,
My lords.
Roman 4.
Correct.
This seems to be the substratum, the heart and soul of your
What your
principal
lordship
point.
would answer.
Right.
Correct.
The only contention is the state's assertion that over and above the amount of royalty fixed by the central government with their active consultation, they can still independently impose levies, exercising its legislative competence under entry 50 list 2 of the 7th schedule. Your principal argument is that every penny of royalty goes to the state, no problem. My Lord Justice Oak pointed out subclause 3 of section 9 of the Act. Just give us some illustration, one or two. What are these? What is the nature of other levies which you are talking about over and above royalty?
It comes subsequent.
Oh, actually.
My lord, in pre-India cement era,
So one clarification.
yes,
Is it your complaint that they are not adhering to Schedule 2, which fixes the rate of royalty? They may be strictly adhering to the price fixed in Schedule 2, but over and above those royalty,
yes,
they are levying some other taxes.
yes. And what they do is,
And your argument is that that is not permissible by virtue of Article 54.
read with 50.
Right? That's your argument. So what are these other levies which is impermissible for the state to impose?
Yes. Please, my lord, come to, my lord, I'll answer that first, my lord, and then come back to, my lord, my
Correct.
page 55, my lord, if your lordship can come. 55, my lord. Please see, my lord, para 93, just to immediately answer my lord's question, my lord Justice
And
Patiwala.
then you may proceed in your own way.
I'll come back to, my lord,
This
that,
will
but
give
yes,
us
yes,
some idea.
it's a, my lord, very pertinent question, my lord. And I also want to highlight this, my lord. This is all which is, it's a bone of contention, my lord, and it's not adversarial, my lord. Ultimately,
Para 55,
para 93, my lord.
page 55.
Yes, my lord. Page 55, yes. Para 93, my lord, your lordships get, your ladyship gets.
Got it.
Yes, I'll read. My lord, your ladyship gets.
Yes, sir.
Yes, sir.
55.
It is submitted that a decision permitting state to impose taxes on mineral rights would inevitably lead to a return to the scenario prevalent prior to India cement judgment. This would be contrary to public interest, etc. 94. To get a sense of the scenario prior to India cement, one may refer to the rates of cess or tax imposed by states at that time as derived from the report of the study group on revision of rates of, this is the source, published in March 90. The rates imposed were this, my lord. For example, the first state, cess at 25% of royalty,
Yes.
then cess at 37% of royalty.
So it's a royalty plus the cess at 25%, which according to you is objectionable and not permissible.
Yes, ma'am. And my lord, please see further. Mineral rights tax on coal at 300% of royalty. Well, today I can show after Kesoram, it's 500% in one state. I don't want to go into state versus center. Then mineral rights tax on other minerals, 100% of royalty. Then please see the next state. Cess on iron ore at 300% of royalty. Then cess on limestone and pyrites at 200% of royalty. Cess on bauxite, china clay, dolomite and fire clay at 133.33% of royalty.
Therefore, Mr. Solicitor, now you have given us the building blocks of your argument by suggesting that, look, if the states are left untrammeled to impose taxes, what would be the impact? States will start imposing radically disproportionate taxes, variant taxes, so on. We've got that point. I think the heart of your matter really is, how do you read the MMDR Act? And you may be right, you can demonstrate that to us, because that's really the crux of the matter. How do you read the MMDR Act as imposing a limitation on the state power to tax under entry 54?
I get them. That's
Right?
the heart of the matter.
So you just spell out now those provisions of the MMDR Act which can be construed as limitations on the state power to tax, because that they also concede that the entry of the states, entry providing for taxes on mineral rights, is subject to the union power to impose limitations. Now the question is whether you have in fact as Parliament imposed the limitations, and which are those limitations. So you can spell out to us, and that really is the core of the matter.
May I come to that answer, my lord, a little later, my lord, 10 minutes later.
Right.
Before that, I want your lordships, my lord, to see how, my lord, Section 9 is understood and how that consultative process has taken place. My lord, it would be necessary, my lord, before your...
Which page of the submission?
Yeah. My lord, it's how, my lord, Section 9 has worked so far. And, my lord, I would also, my lord, why I am not immediately answering this question. My lord, when MMRDA was enacted, there are parliamentary debates that we want to denuate the states from putting any other thing, any other levy. Therefore, my lord, there is some chronology, my lord, which I have conceived. Your lordship can take it from me. There are two types, my lord, as I have earlier also said. That's person who have something to say and person who has to say something. Lord, I would fall in first category. Lord, your lordships can rest assured. Lord, there is something new which, Lord, from the state's perspective, your lordships, Lord, sitting in this combination must know. That's all.
Yes.
Is it your argument that Section 9 is exhaustive of all the levies which a state can impose
Yes.
on the right to mining?
Section 9, read with Section 13, the rule-making power, read with Rule 31, read with, my lord, Annexure F, the Form F. And that I will, my lord, connect. But before that, my lord, some history may be necessary, some facts may be necessary. You must be doing it. Lord, please come to Earnestly request your lordships to see the scheme of the act and the rules in the context of, my lord, what I am going to show, my lord. Please come to, my lord, page 112. My lord, I have produced, my lord, a report, my lord, and for only this, my lord, kindly allow me to use, my lord, the physical copy. There was some confusion at night, my lord, when I read. Some other report was annexed. Therefore, my lord, I have, my underlining is in the physical copy. My lord, I'll revert back to the digital copy, my lord. It's 113, my lords. And in this context, after this, my lord, showing this, I'll immediately come to the scheme.
Group for revision of rates.
Yes, my lord. Immediately, my lord, I'll come to the scheme. This is, my lord, a report of the study group for revision of rates. Please mark this, my lord. This exercise happens every 3 years, as per section 9(3). Your lordships.
The Solicitor General got away by saying, please permit me to use the hard copy. I do not know whether the bench members have that privilege or not.
Lord, I admit, Lord, I am technologically challenged.
No, I put myself in the same footing. and not only you and I, but I'm sure there are others also
Others
in the
also.
room.
No, Lord, but substantially we have shifted. No, what happened was, at midnight, my lord, not midnight, 1 o'clock, when I was, my lord, marking my notes, my lord, so that I can give exact pagination, I found that the annexure, this annexure, was wrongly put. It was another report which was put. So I could not, my lord.
We have the one by Dr. K. Rajeshwar Rao.
Yes.
Yes, my lord.
Same,
So,
right?
my lord, I had the hard copy, so I marked hard copy. Rest, my lord, is I am on the digital. My lord, please come to page 118. How, my lord, this is holistically and at a federal level considered. And, my lord, your lordships may note, this exercise has taken place every 3 years after the act was passed. Section 9, my lord, apropos, my lord, Justice Oak's query, my lords are right. Textually, it does not provide for consultation. But I must point out, when this act was enacted, some states in the parliament said that provide for a consultation, which was opposed by the government of the day, and consultation was not placed as a statutory provision. But it has always been read, and look at the level of consultation which will give, my lord, I am not showing it for nothing, which will give the honorable bench, my lord, the idea why national level fixation of one price and what are the considerations which are going into it, which can never be done if it is fragmented state-wise imposition. That's the purpose of showing this. Please see, my lord, 118, the first para. The principles of, and my lord, kindly, my lord, bear with me, my lord, I'll go a little slowly so far as this report is concerned. The principles of royalty rest on an accepted legal and customary base. Minerals are non-renewable assets which, once removed, cannot be replenished. As owner of minerals, the state needs to be adequately compensated for the permanent loss of an asset thus depleted. Royalty, therefore, whether fixed as a share of profit from the mining industry or as a compensation for a depleting asset, is a consequence of ownership of an asset to which the title is transferred. This is to answer whether it is a tax or not. Please come to page 119. Royalty regime in British India. But it has always been federal dominated. For this reason, my lord. In the British regime, grant of mineral concessions were regulated by Government of India Act 1913. Subsequently, as per the Government of India Act 35, many constitutional changes were brought about under this act and minerals became provincial subject. As a consequence, the then provincial government of Assam, Bihar, Bombay and United Provinces framed their own rules for granting mining concessions. In 1939, the Government of India framed Mining Concession Rules 39 for regulating the grant of prospecting licenses and mining leases in centrally administered area. The mining concession rules specified royalties on mica, petroleum and natural gas, oil, shell, gold and silver, iron ore and precious stones, and the rest of the minerals were not specified. The royalty was based on a specific percentage of the sale value in respect of specified minerals, except oil, shale, iron ore, gold, silver, and so and so. Now, present legislative provisions, your lordships can, my lord, consider skipping and come to chapter 2, my lord, page 121, my lords, para 2.4. Lord, I have marked it, my lord, so that I may not have to read what is not directly relevant. But your lordships can go through it, my lord, at leisure, my lord, if required. 2.4, your lordships have, my lord? 121. Or may I read? With a view to have comprehensive review of the royalty rates on all minerals in terms of its impact on production, mineral-based industries, export and the state revenues, for the first time in the year 1966, Union government set up a study group. This study group submitted its report in 1968 and recommended delinking of royalty rates from the pit's mouth value for most of the minerals and suggested unit of production, that is tonnage, as the basis because of the difficulties experienced by the states in administration of charging royalty as per value of minerals at the pit's mouth, which led to litigations and disputes. Subsequent study groups constituted in the year 73, 78, 84 and 89 retained the tonnage system. Please see 2.6, my lord. As a result of the adoption of the policy of economic liberalization and also as a sequel to International Roundtable Conference held in New Delhi in April 94, under the aegis of the UNDP, the Ministry of Mines constituted a study group in January 95 with a view to rationalize the rates of royalty to make them comparable with the international rates. Please, my lord, mark this. Lord, I am on entire act being read as a limitation and the act is in public interest, my lord. Please, my lord, allow me to proceed further. International rates and at the same time ensure rapid development of mining industry and augmentation of revenue earnings of the state governments. My lord, this is treated as a part of development of mining industry. This national level price fixation is treated as a part of development of mining industry, which is the act. Therefore, my lord, I say the act itself is a limitation. I'll point out the specific provisions also. And it also says that we want to augment the revenue of the states. So therefore, my lord, at the cost of repetition, I'm saying this is not a federal issue. State versus center. Yes, legislative competence of parliament versus legislative competence of state assembly, my lord, is an issue, but not a confrontational federal issue. My lord, then 2.9. My lord, ultimately, I'll, my lord, show that entire act occupies the field as a limitation to entry 50 list 2. That's, my lord, my attempt, my lord. That's why I'm going in a particular, my lord, chronology. 2.9, my lord, next page.
Extent provided.
Okay, consequent to the notification of royalty rates in 2004, a high-level committee was set up under the chairmanship of Sri So-and-so, Member Planning Commission, to review the national mineral policy and recommend possible amendments in the MMDRA. The recommendations of the HLC in respect of royalty were as under. Please see only D and E. A lowering of rates to be considered only for such mineral for which there is evidence to show that the royalty rates are inhibiting mining operations and mineral production is registering a downward trend. They have studied and, my lord, recommended this, and these recommendations are the foundation for subsequent, my lord, fixation of royalties. The royalty rates of base metals noble metals, and precious stones in which the country is grossly deficient needs to be low to encourage exploration for these minerals. But this also cannot be done fragmented way by the respective state governments, and the act, my lord, as I will show the architecture, acts as a limitation on any other taxing power. Then your lordships may, my lord, kindly turn the page and just 3 lines above para 2.11, PDF 124, 4 line, my lord. This schedule to the Mines and Mineral Development Act on an escalating scale, taking into consideration measures for effective deterrence against the mines, both the recommendations of this study group, the revised rates of the royalty, etc. Then 2.11. The period between 2007-11 witnessed significant development in the Indian mining sector, mineral sector. Based on the recommendations of HODA committee, Government of India in consultation with state governments replaced the National Mineral Policy with new National Mineral Policy on 13th March 2008. The National Mineral Policy provides for a change in the role of the central government and the state governments, particularly in relation to incentivizing the private sector investment in exploration and mining and ensuring level playing field and transparency in the grant of concession, etc. My lord. Now, please, my lord, turn the page over, my lord. Chapter 3. PDF 126, my lord. I'm sorry, my lord. Lord, there a global view is examined by the committee, and this is examined every time when there is a revision of royalty rates takes place. Lord, please come to last para 129, my lord, last 3 lines. Lord, these are all factors, my lord, which would lead credence to my argument subject to your lordship's, my lord, approval, that the act, architecture of the act and reading section 9, the way, my lord, the central government has read, operates as a limitation contemplated under entry 50. Lord, last 4 lines. It is evident, your lordship gets, my lord, 129. It is evident that prevailing royalty rates in other countries are much lower than India and mainly in the range of 2.5% to 7.5% on ad valorem basis. For ease of comparison, 15 mineral-rich countries have been considered based on significant occurrence of the specific mineral. This is the examination which, my lord, is taking place every time there is a revision in fixation of mineral rates. Then, my lord, kindly come to next, 130. And that is where, my lord, the government's concern comes, and that, my lord, would, my lord, possibly persuade your lordships to treat the act itself as a limitation, apart from 3 or 4 specific sections which I'll show. Because the act is, my lord, please bear in mind, providing for development and regulation of minerals. And once the field is occupied by provisions which makes the development possible and regulation possible, Lord, I will show some of the judgments. The regulation would also mean prohibiting taxation.
It could have been expressly provided under the Act, a prohibition on taxation, but that is not there.
Lord,
Can we imply
I'll answer that question straight away. It is not provided.
It is not provided.
But, Lord, no statute, my lord, to my knowledge, would provide a negative provision that you, the state legislature, will not tax. It occupies the field, and the resultant constitutional effect is your power of tax is taken away. I will come to that, my lord, but I want your lordship and my lord, ladyship to see this. Then I am coming to, my lord, I'm aware. Whatever is the extent after section 2 is the extent of limitation.
Yes.
That's your, I bow down. That is the correct position. It's not that it's controlled everything my lord, under the universe. My lord, it says whatever is
What is beyond what is provided is the question now.
correct. To answer that question, I'll have to necessarily go through this chronology.
Yes.
Whether, my lord, it is entirely your lordship's discretion to accept it or not, but your lordships must have, my lord, the background in which, my lord, your lordships are examining the question, because this is a 9-judge combination, and, my lord, the law laid down will have huge impact, my lord, on the economy of the nation, import-export policy of the nation, and the domestic production industry of the nation, because these are all used in core manufacturing and other domestic industries. Lord, and therefore, my lord, this was the position even when the constitution was framed. Therefore, only entry where taxing power is subject to some limitation. I know I have to answer limitation found where. I'll answer that. But please see, my lord. Section 9 has been, my lord, the consultation is read into it. Why, my lord, the state needs to impose any further levy for augmenting revenue? That is taken into consideration while fixing the royalty. To answer, my lord, her ladyship's query, my lord, again, putting it in a different way. There is no negative provision in the state, in my lord, the act, that state legislature is denuded of the power, because no legislative drafting would have such a provision. Negative provision is not required. How, my lord, that negative provision is
You're saying
ensured?
you are implied, according to you.
No.
It's implied.
Lord, by occupying the field. Lord, if I am sitting on the chair, Mr. Dr. Singhvi cannot sit on this chair by occupying the.
We don't think that he will do that.
No, the question is,
Mr. Solicitor, we don't think that he will do that. He will even attempt to do that.
So, my lord, I don't have to, my lord, say that no, Dr. Singhvi will not sit in this chair. I occupy the chair. But look, that's my answer.
but the question is, what is beyond the chair? The chair is not exhaustive of everything.
That's what
There
I'm
is something beyond the
The-
chair which
Lord,
is
it
not
is, Lord,
occupied.
I'll show, my lord. My lord, when the fixation takes place, everything beyond the chair is also taken into consideration. It is, my lord, as my lord the Chief Justice said, it's a block. It's all inclusive. My lord, MMRDA is a complete code in itself. When it provides for fixation of fiscal levy, it exhausts all fiscal levies. That is my respectful submission. Lord, please come to, my lord, para 4.4. Lord, that is 131. And this is what, my lord, would be the problem, my lord, if India cement is to be disturbed, my lord, and Kesoram is to be. I'm not worried about India cement or Kesoram. I'm before a larger bench, my lord. Neither of the judgment binds. I'm sorry. My lord, 131, para 4.4. This is, my lord, very crucial. Indian mining sector is carrying the burden of highest taxation in the world. The effective tax rate, for example, in case of iron ore, works out to be as high as 64% in case of the mines granted before 12th January 15 and 60% in case of the new mines granted after 11 January. My lord, your lordship knows in 2015, auction regime took place, my lord. Otherwise, it used to be first come, first served, etc. Against this high incidence of taxation prevailing in the country, the internationally effective tax rate is in the range of 31% to 45%, as depicted in the table given at the end of the chapter. The mining sector in India is heavily taxed, and not only in comparison to international level, please mark this, but also in comparison to other domestic sectors.
Yes.
The taxation regime for mining in India affects all downstream industries and employment opportunities in the country, while fueling the already skewed balance of payment through additional import of minerals. Here, hence, there is a need to rationalize the taxation structure. No, they do not say royalty. They are rationalizing the taxation structure on minerals. Taxation structure for the mining sector for sustainable development and deriving long-term benefits in terms of sustained raw material security for the industries. We can't exhaust everything in 10 years, but our structure should be such that it competes with several factors. Then they have gone to effective tax rate, value of all amounts paid to the government. Please mark this. Kindly underline the word all, or. Value of all amounts paid to the government and divided by total revenue from mineral sales. Please, my lord, come to the next page. My lord, mainly, my lord, they have given mineral producing countries and compared with Indian position. Mongolia is this 31.30% effective tax rate. Similarly, Canada, etc., etc. Last two are India new mines, that is after 15, 59.84, and old mines, 63.97. This is the taxation structure as compared to global. And this includes everything which is payable to the government, including royalty. So they are deciding the fiscal structure, not royalty only, keeping in mind every fiscal levy which is permissible or impermissible. Except, my lord, what is, my lord, quoted in the at the bottom. ETR does not include a number of other payments such as auction price. Now after 2015, my lord, I have to participate and I'll have to pay premium. Auction price, purchase of land for mining, GST at 18%, 10% tax levied by Supreme Court. It's a wrong word, not levied by levied under the judgment.
That's right.
Levied under the judgment of the Supreme Court. Levied by the Supreme Court in Goa and Karnataka, and FDT levied by Karnataka, as well as highest rate of royalty on iron ore in Odisha. Because they are imposing their own levies. Odisha and Karnataka are imposing their own levies. That is also considered. That is not considered still. Still, this is the high level of taxation. Net present value in case of survey in forest land, I am not going into details. Net present value is 4.38 lakhs to 10.43 lakhs per hectare, depending on density of forest at the time of grant of lease. Then compensatory afforestation, etc. Now, please come to the next page, my lord, where, my lord, the total fiscal payment is, my lord, decided. One of the main objectives of the study group as laid down in terms of reference is to review and suggest changes in the second schedule to the MMDRA. My lord, second schedule contains, my lord, the royalty. uh, regarding the royalty rates, keeping in view the objective of mineral development, please see, this is an exercise in the interest of mineral development, which is a field occupied by the central now. Because they are not only deciding what amount will get to which state, they are examining how the national development in the sector of minerals will take place. How would we regulate the mineral sector and mining sector in a fashion that it is developed? So this amount is, my lord, under the act providing for development of minerals. Then your lordships, my lord, kindly see 5.2. The study group had a series of meetings on so-and-so at Hyderabad for deliberating the methodology to be adopted, in-depth analysis of international and domestic demand-supply scenario, price trends of principal commodities, because they use raw material, my lord, minerals as raw materials, review of taxation and fiscal regime, please mark this, my lord, and fiscal regime, and engagement with all stakeholders to formulate the final recommendations of the study group. Well, this exercise is undertaken at the cost of repetition every 3 years or 4 years, whenever there is a revision in the fiscal regime. Then your lordships, my lord, kindly come to the next page, para 5.5. My lord, they prepared questionnaires, 2 questionnaires, one sent to, my lord, the affected parties, my lord, that is mining industry, and second to the state governments, so as to decide how the final figure is to be arrived at. Para 5.5. The questionnaires were also circulated for seeking information from the stakeholders with regard to the criteria for fixing rate of royalty, preference for ad valorem basis or tonnage basis for charging royalty or minerals, periodicity of revision of royalty, perception of the state government for the revenue earned for the imposition of royalty, utilization of royalty for infrastructure development, environment protection, guidelines on charging of royalty, guidelines for computing royalty on minerals on ad valorem basis, separate entry for so-and-so, so-and-so, so-and-so. Now kindly see, my lord, next page, new factors since last revision of royalty rates and dead rent, because 2015 regime, that is, my lord, the auction regime steps in. After the notification of royalty rates and dead rent in September 2014, there have been major changes in the legal framework by way of effecting the MMRDA with effect from 12th January 15. As per the amendments, mining leases are to be granted through auction. Your lordships can, my lord, skip that, my lord. And, my lord, kindly come to the next page. Criteria for determining royalty rates. 5.9. Your lordship gets 5.9. In determining the royalty rates for minerals, the study group assessed the following parameters: grant of concession through auction mechanism and imposition of contribution to DMF plus NEMT, leading to hefty revenue generated for the states. Lord, kindly pause here for a minute. Now there is a new insertion, that is 9C, under which, my lord, every mining operator will have to pay 30% of the royalty to the state, my lord, which is being used for the purpose of mining affected persons and environment, not, my lord, for general welfare of the people. And, my lord, this national is, my lord, minimal, but that comes to the center. Then impact of high burden of taxation, especially in comparison to international mining jurisdictions. But this can never be done at the state level in a fragmented way. It has to be at the federal level. Then dependence on imports of minerals. Lord, sometimes what happens is, Lord, some mining leaseholders, they stop mining, which is required, my lord, for core industries as a raw material. So the country is dependent upon the import of the minerals. That is considered that we will have to fix the fiscal structure in such a way that import is minimum and we use the domestic production at the optimum. And my lord, the prices go high. Prices of the end product goes high. If we import the minerals to be used as a raw material, the end product in the core industry sector will go high. That is the concern, which can never be done at the state level. Then, my lord, sluggish growth of mineral sector and declining trends of its shares in country's GDP, trends in domestic production and export quantity and prices of mineral. No, there is, this is also considered that you are less incentivized to export your minerals and give it to your domestic users. Cost of mineral production, cost of transportation and handling charges, implication of revision of royalty rates on revenue realization of the state government and in the industry. Please see this, my lord. Unused stocks of low grade, etc. Your lordship can, my lord, skip. Next page, only two para, 5.12 and 5.13. One of the objectives of the study group is to devise a royalty regime which is effective, transparent, stable, and is attractive to the investors to invest in the mining sector, particularly for mineral like copper, gold, silver, and diamond. So they are using the word revenue, royalty, but they say that our attempt is to ensure that more and more investors come and that results in development of mines and minerals. So that is the scheme, that is the architecture of the act. Then view of the stakeholders. The study group has tried to obtain the view of stakeholders, etc. My lord. Now, my lord, may kindly see, I'm just giving, my lord, an overview of how my lord, this exercise progressed. Please come to page 138. Now, my lord, they take one mineral. Lord, view of the stakeholders. My lord, the first stakeholder for this particular mineral is Ministry of Steel. Can never happen, my lord, if it is fragmented state-wise. Please see. Was of the view that currently India has the highest rate of royalty on iron ore, that is 15% of average sale value amongst major iron ore producing countries, and thereby having highest taxes at 64% of effective tax rate. Ministry of Steel made the following recommendations. I am not going into it. My lord, then please see. B. Government of Andhra Pradesh. The main recommendation, please see beach send. Increase of royalty rate to 4% from existing 2% on ad valorem basis for limonite, siliminate, so-and-so and so-and-so. They take into consideration what fiscal benefit we want to derive out of the mineral wealth which we have in our country, and therefore they make a request and they give justifications, and acceptance and rejection of request are answered in this report with reasons. Please see, my lord. Then, my lord, please see next page, my lord. Government of Andhra Pradesh, my lord, iron ore. They, my lord, say this. Please see, my lord. Continue, my lord, 4. Your lordship have Roman 4.
Yes.
Continue existing rate of royalty for iron ore, 15% of average sale price on ad valorem basis, irrespective of the grade of the ore. They say our coffers would be enough if we get this much out of our mineral wealth. Then, my lord, they say that to introduce 2 new price slabs for the low grade iron ore, etc. I'm not reading individually. I'm saying that every state represents that you are deciding the fiscal receipt which my state will get. Please increase this, please bifurcate this, please decrease this, etc., etc. My lord, C is government of Chhattisgarh. I'm not reading. My lord, D is government of Gujarat. They have their own views. My lord, I'm not reading. E is government of Jharkhand. I'm not reading. These are just examples that every state participated per mineral. Look, this is an exercise per mineral because every mineral has its own economic parameters, and every mineral will have different stakeholders contributing their suggestions. Then, my lord, please see F, government of Madhya Pradesh. The rate of royalty on diamond should be increased from 11.5% to 15%. They say that we want something more from our diamond deposits because Madhya Pradesh seems to be a diamond rich state. Then government of Odisha, government of Telangana, then Manoj kindly come to my learned friend wants me to see show to your lordship Telangana. It was highlighted by government of Telangana that the fixation of royalty should be based on unit or volume instead of ad valorem, mainly for adequacy, administrative efficiency, revenue stability, transparency, and simplicity in monitoring royalty collections and reconciliation. This is important. It was also pointed out that the present royalty regime, that is royalty, DMF, that is district fund and national fund, etc., imposes higher tax burden on mining sector and is high comparatively with other countries relating to effective tax rate. They say that decrease this because internationally there is a low tax regime. We have higher tax. And their concern is they might lose the industries which are using this particular mineral. So they have their own concern. Then next is FIMI. FIMI is Federation of Indian Mining Industries. So they have also participated. I am not reading it, but this is a stakeholder participation. Now your lordships may go by one or two examples of the minerals. Page 148, para 6.4. This is how the development and regulation of mineral is taken care of as a general architecture. 6.4. An analysis of the feedback given by the state government show that principal mineral producing state perceives royalty primarily as a source of revenue as well as consideration for permitting exploitation of state mineral resources. These states are also of the view that royalty is a consideration due to the state government for allowing exploitation of its mineral resources besides a tool of source of fund for local area and community development. They say whatever figures we are suggesting is for our development. It goes in consolidated funds of India. It's not for growth of mining industry only. It's their revenue generation. It's like income tax by the central government. It goes in the consolidated fund of India. This goes in the consolidated fund of the state. Then, my lord, the state governments in general gave priority for increasing the revenue earnings from royalty as criteria for fixing the rates of royalty. Further, the states sought to consider optimum utilization of low-grade mineral resources, fiscal measures for attracting investment. Please. Fiscal measures for attracting investment and mineral conservation as other important criteria for fixing royalty rates. Some states are also of the view that criteria of fixing the royalty should be to attract improved technology to bring royalty rates in tune with international rates for encouraging investment in mining sector. They are saying that this is an all comprehensive package which we are deciding. FICCI recommends that differential rates of royalty should be charged on intermediate minerals, etc., etc. We are not concerned, my lord. Now, please see, my lord, one example. My lord, kindly come to, my lord, dead rent. And I'll again show, my lord, how this is a limitation. How this helps development and regulation. My lord, what is dead rent? Let us see conceptually, what is dead rent. Lord, I have a mine. I am not operating the mine for whatever reason. So I'll have to pay dead rent. That is the dead rent. Lord, why do we charge that as a concept? Lord, it's not merely, to incentivize the mine owner to continuously mine and produce minerals. There is one more important factor, and that important factor is this. Lord, your lordships are aware, my lord, the mineral resources of the country are limited. They will be depleted. And they are to be exploited in a phased manner. When I get the lease with a condition that I would extract minerals over a period of 10 years for sustainable development to ensure that simultaneously the ecology is not harmed, etc. Suppose I am greedy or for whatever reason, my lord, there are some market forces, the price of that mineral has shot up. Instead of 10 years, I deploy more manpower, more machinery and more equipments and do everything, my lord. If I have to extract 5,000 tons, I do it in 3 years. I would be harming the environment, I would be harming the sustainable development, and therefore for 7 years, my dead rent would be so high that I am disincentivized to do in 3 years. This is development of mineral. Therefore, I say the entire act is a consolidated, self-contained code for every aspect of development and regulation of mineral. Lord, this number 2. Lord, in the example which I have given, I'm sorry, sir.
Yes.
Another, Lord, why dead rent and how it is directly linked with the development and regulation of mineral. Every section has, Lord, this theme. Lord, suppose I do something in 3 years which I am supposed to do in 10 years, it would directly impact the price structures. Therefore, a provision for dead rent. Lord, each and every provision has, Lord, ultimate goal of development and regulation, but I am showing this to show that every state also comes before the government saying that this is the all-in-all package for my fiscal benefit and this is how you decide the package. Lord, 58, my lord. Just, my lord, giving an example, how, my lord, now, my lord, this exercise is undertaken per mineral. This is not a general exercise. Per mineral, stakeholders are asked, stakeholders give their details, their desires. Global analysis. Now for bauxite, after considering each state's request for increase, decrease, change in methodology, etc., the central committee goes into the global analysis. Aluminum industry is the principal consumer of bauxite. World production of aluminum was 58 million tons in 2015. China continued to be the leading producer with a share of about 54%, which is followed by Russia, Canada and UAE and India, 4% each. Global aluminum demand of so-and-so, but I am not reading everything, but they examine the global scenario qua bauxite, keeping in mind the demand, request or desire of every state government for their generation of fiscal revenue. And 163 is the conclusion. Yes, my lord. Kindly see, my lord. Keeping in view the global consumption production trend, analysis of global royalty rates, increase in production cost and future domestic demand. Look, kindly see the parameters they are considering. This can be considered only at the national level. That production cost has gone high, future domestic demand. The study group recommends that royalty rate for metallurgical grade bauxite be reduced to 0.45% of LME prices so that net impact including DMF and NMET remains same as 6.60%. Please mark net impact, including two statutory levies under the MMDR. I hope, Lord, I am able to, Lord, make myself clear. Lord, these two, EMF is, Lord, fund created under 9C, and NMET is a fund created under 9D. So they say royalty, DMF, and any NMET, considering that the net impact is only 0.60%. And net impact would mean whatever you wanted is given or not given for a reason, but you cannot levy anything more. Constitutionally, I will answer how can we say that. But this is how the exercise takes place. So just by 194, my lord. Just, my lord, I will not read this. I can assure your lordship I will not read this. But for limestone, so impose cess, etc., which is not a tax. And royalty in any case is not a tax. That's not the issue I am right now raising. Please see limestone, at page 194, 193. I am not reading it, but where every state had different justifications for increase, decrease. But eventually, the committee, after taking into consideration everything, at page 194, 85, 194.
And the manganese 80%, 83.
Your lordship may see the bottom. Then I'm through. I'm done with this. After analysis of data on cement price for the last 3 years, impact of limestone as raw material cost and its significance for infrastructural growth, the study group recommends to adjust royalty rate of LD grade limestone to rupees 70 from rupees 90 per ton and other grade limestone to rupees 60 from 80 per ton, so that the impact of DMF and NMET gets cushioned and absorbed for auctioned mines only, meaning thereby only 3 levies are being contemplated. The reason is this, my lord. Limestone is directly used, my lord, for manufacturing of cement, and cement is required for the core infrastructural growth of the country. What they say is we will have to cushion these 2 charges, meaning thereby it's very clear that they are providing for an all-inclusive fiscal benefit to each state.
Are the states told by the study group at any point that, look, in lieu of your taxing revenue, what is it that you require by way of total revenues to be generated, so that we will take royalty, fixed royalty, take into account your overall loss of taxing revenues? Does that exercise happen? We find only that they have said, well, to cushion the payment of DMF and NMET, the reduction of rates of royalty in certain cases has been recommended. Because after the 2015 amendment, they have to pay to the National Mineral, the District Mineral Fund and the Exploration Trust.
Yes, district fund.
Right. But is there anything here to indicate that the states are told that, well, what is it that your revenue generation requirements are?
No,
and
not
therefore, when
only
we fix the royalty, we will take into account your loss of tax revenues.
I get that. Lord, my questionnaire, Odisha. Questionnaire which is sent to the government, state governments. Lord, page 148, if your lordships can come to, my lords. Para 6.4.
You are right that throughout the study report, the study group's report, they keep on saying that, look, we have to cushion the impact of the DMF and the NMET.
Meaning
But
there
is
might
that
be
really
more.
right? Therefore, you are because of the DMF, the states are getting this additional levy. The industry has to pay extra, so that we will cushion that impact by reducing the rate of royalty.
So, meaning thereby nothing else. So otherwise, my lord, there is no question of cushioning. My lord. Even they are going to the extent.
Nothing else is the key. See, where do you get that actually?
I'll, my lord, come to that. But lord, just answering your lordship's question.
Because we saw that
If your
everywhere they are saying to
lordship
cushion the impact of DMF, NMET.
Lord, if your lordships are looking at a specific negatively worded provision, there is none. That nothing else, this and nothing else, because legislature do not use such language, my lord, for another legislation, a negative language. They occupy the field, and I'll show the field is occupied.
Only to the extent provided.
Exactly.
In the section-
I'll show the extent. Your ladyship is right. I'll show to what extent it is provided.
In fact, the provision appears to be
Yes,
to
I'm
compute
sorry.
the effective rate of tax. The effective rate of tax is the total amount which is paid to the state, divided by way of royalty and other levies, divided by the total realizations on account of sale. Then they say that the effective rate of tax is very high in India, and therefore perhaps the royalty rates have to be so modulated.
That would, in my submission, necessarily mean that if you put any other burden, the balance at the national and international level will be disturbed. That's the only similar. Answering my lord, the Chief Justice's query, Lord, please come to PDF 136. Criteria for determining royalty rates. Your lordship gets it, madam? Your lordship gets me, can I read? Lord, kindly come to F and G. F. Lord, I'm not reading the rest.
But see, B, for instance, impact of high burden of
Yes.
taxation, especially in comparison to international mining jurisdictions. So, does this not really, therefore, seem to contemplate that there is a duty to pay tax to the states? The burden is high.
No, no.
And therefore, we are fixing the royalty to modulate the burden of taxation.
No. Lord, the impact of high burden of taxation would mean that as per the global phenomena, our fiscal regime, I'll use a use a neutral word, that our fiscal regime has high taxation. But therefore, my lord, I have shown to your lordships what it includes and what it doesn't include. My lord, please for a second, my lord, just to answer, my lord, come back to, my lord, that high taxation part. Value of...
Mr. SG, query of
Means that there is-
Honorable Chief Justice was
Yes.
very fact that clause B refers to high burden of taxation,
Yes, my lord.
it itself contemplates that states will continue to levy taxes.
My lord, I am
That will be
answering.
taken into consideration while fixing the royalty.
Correct. My lord. I am answering that.
Right.
My lord, please come to 19.
Is the only way.
132. My lord. 131. I'm sorry. 131.
As you rightly said,
May I answer that, my lord, possibly?
royalty, though fixed by the union, is entirely appropriated, levied and appropriated by the states.
Correct.
Right? Now, therefore, when they are fixing royalty, they are fixing the price which the states will realize for the extraction of minerals of which they are owners. Right? That's the whole concept of royalty. Also of dead rent, that because you don't extract, you have to pay dead rent. Now, while fixing the royalty, which is a realization by the states for the extraction of minerals, the study group looks at what the state is already realizing on account of taxation. And it in fact says that because there is such a high burden of taxation which the states are imposing, therefore we will modulate the royalty accordingly, which postulates again that taxation is something which the states are imposing. In fact, it's not the other way. That look, we are increasing the rate of royalty to a level so that you will exclude all other levies.
Can I
That's
answer
not the
that?
approach
Can I
of the
answer
study
that?
group.
But there is an answer. There are two answers. Please come to, my lord, page 131 at the foot. 131.
Nor are they fixing royalty to compensate for the loss of tax revenues.
It's there, my
it's
lord.
the reverse.
I'm showing that. My lord, if your lordship can just bear with me. Page 131.
131.
131. My lord, how, my lord, the effective tax rate is calculated? 131 bottom. Your lordship gets, my lord?
Yes.
Value of all amounts paid to the government by the minor.
Mr. Solicitor,
Only a minute.
this goes against you. If effective rate, if the numerator in the effective rate of tax were to be the value of all amounts paid to the government on account of royalty,
No.
then you would be right.
No. Kindly, my lord. Kindly, my
When
lord,
they
give me.
factor in all payments which are made to the state.
We try and read, my lord, it that way, but kindly read it other way. That everything which the...
And because
No, one thing is clear.
because the product of this division, the numerator and the denominator, is so high in the case of India, almost 60%. Therefore, they wanted to impose a more realistic royalty regime by, in fact, reducing the rate of royalty.
Can I answer that one? Can I answer? Oh, first and foremost, when this report is prepared, Kesorami holds the field, and therefore there were levies. There are levies. So that cannot be ignored by the study group. Correct, my lords? After Kesoram, the state is imposing levies in some my lord, states. It's 500% of that of the royalty. So it says value of all amounts paid to the government. Please, my lord, now turn the page. That would get, my lord, the answer, my lord, of what my lord, the Chief Justice, my lord, put.
India 59 and 60.
59 and, my lord, that's okay. But note, what it does not include. First he said everything which is paid to the government. But except this, my lord, please see, ETR, that is effective tax rate, does not include a number of other payments such as auction price, purchase of land for mining, GST of 18%, 10% tax levied by the Supreme Court, net present value in case of survey, net present value, compensatory afforestation, upfront payment at the time of grant of mining lease.
But it therefore does not exclude the state cesses. It includes the state cesses.
That's exactly
right.
what
You
I'm
may be
saying.
right. It's because of the prevalence of Kesoram. Because when the study report came, we were in the Kesoram regime,
Yes.
where the states can levy cess. But the fact remains that this study group postulates that the rate of royalty would be so modulated so that the amount which is realized by the states towards royalty is adequately reduced to factor in the high rate of taxes which the states are otherwise imposing.
My lord, would your lordships come to a 2-page thereafter, my lord? 5.9. There are 5.9.
Methodologically, the study group is not saying that, look, We are now going to give you an adequate realization by way of royalty so that you do not impose any other levies. That's not what they are telling the states.
The other hand, this
136,
this
if your
this
lordship comes.
exclusion clearly states that there are other types of exactions
Right.
which the states can do. For example, in Karnataka, forest development tax or FDT is levied on forest produce, which also includes mineral resources.
So that is the question, my lord, whether it can be levied or not. That's the question. Whether it can be levied. But that's the question. It is levied. My lord, in every state, under some name or the other, it is being levied. But my lord, my reading of, my lord, this page 131 is that how tax rate is my lord, derived, all whatever you are supposed to pay, state tax, royalty, district fund, national fund, everything, multiplied by this, except ABCDE, which does not in the exceptions or deductions do not take care of state. And here, apropos your lordship's query, my lord, please come to page 136, whether it is considered or not, that what is your revenue requirement. Point G, my lord, I stop, my lord, at 5F, but please see G. Implication of revision of royalty rates on revenue realization of the state government and the industry. This is inclusive.
From royalty. That's right.
But if, my lord, if we, my lord, there are always two ways of reading it, my lord. But, my lord, what they say is that what will be the implication on the overall growth of, my lord, this sector and how it would impact. My lord, if I don't, my lord, wish to take your lordship through every mineral, my lord, wise discussion, what they say is this is the total amount which a miner pay. This mineral is used in ABCD industry. This is the position in the global market. And if we do not put the cap of total fiscal payment at particular point, it would be against the development of the mining industry. That is how, my lord, they have proceeded. Lord, the difficulty for me is
states were compensated through
Lord, after, Lord, I'll come to the act immediately.
B.
Lord,
B and G also.
Lord, after, Lord, I'll come to the act immediately. But apropos this query, my lord, after India Cement, when the state was not permitted, my lord, to levy anything other than royalty, they were compensated by the respective study group by increasing royalty. So it is always considered as a composite receipt by the state. Lord, please, my lord, come to volume 5, only one paragraph, page 1569. Lord, this is a Mahalakshmi judgment. State of MP versus Mahalakshmi Fabrics. So when you are not levying the other charges, you are compensated.
Volume 5, right?
Yes, my lord. Volume 5, page 1569. It starts at 1561, my lord, but I am pointedly inviting your lordship's attention to the relevant part. PDF is 1575. I'm sorry, 1575. 1575. Left side PDF.
1567.
1.5.
Your lordship gets, my lord? Left hand side, my lord, pagination 1575. PDF pagination. My lords, my lord, get it, my lords?
Yes.
The Lord, first, the controversy ultimately came to be decided by this court in Orissa Cement versus State of Orissa, whereby such cess was held to be invalid and beyond the legislative competence of the state government. It appears that soon after the aforesaid invalidation of the cess, the coal-producing states were faced with problem of refunding the amounts obtained by them that far. They therefore approached the central government for help. In pursuance to the said approach, Parliament passed an act validating the cess so that they don't have to repay it to the government, repay it to the miners. We are not concerned. We are not concerned with the said ordinance and subsequent act in the present proceedings. It appears, please note this, that since the state government had suffered financial losses because of the invalidation of cess, they also approached the central government for help in the matter. As a consequence thereof, a working group was constituted in this behalf. The said working group suggested an increase in the royalty to the extent of 17% per ton of coal. The working group also found sufficient justification for compensating the coal producing states to the extent of 100% of the loss caused by the aforesaid judgment of this court. Since the recommendation was accepted by the central government, the impugned notification was issued by the government according to the writ petitioner before the High Court. The increase in the rates of royalty pursuant to the notification was to the extent of 400% to 2000% as compared to the royalty fixed in 1981 on various varieties of coal. It was further contended, etc. My Lord, the point I am making is, when they were prevented from taking any levy, that loss was compensated in the fixation of royalty. And when they are, my Lord, now permitted to levy because of Keshav and subject to what your Lordship decides, my Lord, the royalty is so fixed that it also takes into account that you are already earning this much. Because this subgroup, my Lord, cannot sit in appeal whether it is leviable or not. They will have to proceed that as on date it is leviable. You are earning 100 rupees.
In other words, the fixation of royalty is not agnostic to what the states are realizing by way of taxation.
Because of Keshav. Yes. Yes. Therefore, my Lord, therefore this reference.
It isn't that the states are entitled to demand something by way of tax and they adjust the royalty every 3 years.
Now, my Lord, what would happen? In practical terms, what would happen? If your Lordships hypothetically were to hold that the state had no jurisdiction, competence, state legislature had no competence to levy a particular levy other than royalty, dead rent, and my Lord,
You are saying that the government of India will increase the royalties.
Because that will, somewhere we will have to have a national perspective. Lord, we will have to have national perspective, keeping in mind the global scenario, and this exercise cannot be left to the provincial interest. Narrow provincial interest. Narrow, I'm not using it in a bad sense, but when I'm deciding for one particular state, my Lord, my examination would be a narrow examination. I would not take a holistic national approach, and in any case, I cannot take global factors into consideration.
Side. See, if a state is so risky, the market will provide for greater imports.
Yes.
If there is a greater amount of imports, the states will lose their revenue because there will be no demand for locally produced minerals.
My Lord, the nation loses, my Lord, when import increases,
right.
That's exactly what, my Lord, I am driving at. That if the domestic production is less because of high taxation, the import starts. That's what we are, my Lord, avoiding. We want, only give me a minute, my Lord.
The state will never want to be in a situation where by overpricing overtaxing the product, it starts losing its revenues. Because if it overprices the product, it's also a matter for demand and supply for the state. If it overprices the tax rates, if it overcharges, then obviously there'll be a greater incentive to import, as you're rightly saying. In which case, it will impact upon the state revenues.
Sometimes suppose they undercharge it. They undercharge it and start exporting. Lord, the idea is that on the national level, a holistic decision is taken that our minerals, which are our national resource, are used for domestic production of infrastructure and core industries. And therefore, this is one way of controlling import or export.
Just one, what you are trying to show is exercise done once.
No, every 3 years it is done.
Yeah, it's very slightly different.
I'm sorry.
we are not considering how the royalty is being fixed by the central government. We are considering only a very simple issue, whether power to impose royalty is itself sufficient to draw an inference that states are denuded from the power under.
Please come to the act, my lord. Please come to them. I know, my lord. That's the heart.
Suppose in a given case, tomorrow central government says that we want to impose royalty of say only 10 rupees. There are power to impose royalty of 10 rupees. So can you say that in the states can't levy the tax? In a given fact situation for a particular year, the government may have undertaken this exercise of talking to the states, taking their feedback. We are really on the question whether only because there is a power to levy royalty, the power of the states to take taxes is.
I'm answering that immediately. Factually,
Right.
look, this is not a one-time exercise. This is an exercise done whenever there is a revision of royalty. That is every 3 years, sometimes for not 5 years. So this is how the section 9 is read. The consultation is read into section 9. That is one. The consultation with the state to arrive at a consolidated figure is read into. Now please see section.
It's public interest. It doesn't happen.
Metaphorically, just taking from what Brother Oak was.
Lord. Yes. My lord, my respectful submission, giving, my lord, taking the example, my lord, metaphorically as your lordships are taking.
For example,
If my, yes, my lord, if my intention is to occupy it exclusively, then he is ousted. My lord, apropos my lord's concern, and a very valid concern, that market forces can itself arrive at a particular decision making. For example, your lordship said, give me a minute, my lord, to answer, that state if overcharges, then state would not get the revenue and therefore market forces would ultimately, my lord, settle down the issue. My lord, that takes a very long time. When we rely upon market forces to settle down an issue, the damage is done. And this is damage about our national resources, and damage would be national level. My lord, the mistake would be, or whatever decision would be of a state. My lord, your lordships are examining this as a federal issue.
To use Brother Rishikesh Roy's example, your submission is that, look, because I'm occupying my chair, Dr. Singhvi is ousted from occupying his chair.
No. I'm sorry, my lord, I'm sorry. Only a minute.
That's why I said, what lies?
No. I'm sorry, my lord.
No, that is why I said, what lies?
My lord, I would answer, my lord. My submission is, there is only one chair in the room, which I am occupying with an intention of ensuring that nobody else, including Dr. Singhvi, occupies the chair. There are no two chairs here. Your lordship's, my lord, example presupposes two chairs. I am saying, my lord, there is entry 54. 50 says, if there is a law under 50, you are out. So there is a law under 50, the field is occupied. And there is only one field. That is mineral development and regulation and development of minerals. So, my lord, my metaphoric example was when there is only one chair and I occupy the chair with an intention of excluding others. And I am giving, my lord, why I gave all this, my lord, because I have to show public interest. It's not, my lord, just that state center wants to act like a big brother. There is a public interest involved, my lord, as entry 54 stipulates. My law is not just, my lord, for development and regulation. To oust or to be treated as a limitation, it must be in public interest also. That's what I was showing. That why this has to be done at a national level and not at provincial level with some narrow my lord, considerations weighing. And your lordships are right, my lord. Sometimes a wrong decision by a state to overprice may damage the state, and after 3-4 years, the state may come down. But what happens within that 3-4 years? That's the question, my lord, which will have to be asked.
One other perspective is, in the context of royalty, the Central Act or the Parliament is permitting the states to levy royalty. But what is the limitation imposed on
No,
the
not levy.
No,
Parliament
they are
doesn't permit me to levy.
The state is levying the royalty under the Central Act.
No, my lord. What
It's not the center which is levying the royalty.
I am only fixing the rate.
Correct. That is the only limitation on the right.
No. My lord, my
fixing of
submission
the
is, now examine that submission. Examine that submission. My submission is,
royalty, the states are.
state.
So Parliament is enabling the states to collect royalty.
Yes, not,
But the
yes.
limitation is only on the rate of royalty.
Correct.
So that is a constitutional limitation in the context of entry.
That is their submission that the
No, under the Act.
that's, my lord, I have to yet, my lord, convince your ladyship. But their submission is that Section 9 is the only limitation, and since Section 9 does not prohibit other levy, we can have law providing for other levy. But that submission is wrong, my lord. That's what, my lord, that's the main dispute.
Yeah, you are going to go to the act now, I suppose.
Yes, kindly, my lord. My lord, kindly come to the statement of objection reasons. The differentiation made between petroleum and other minerals in item 53 and 54 of the union list has rendered separate enactments for the two necessary. The present bill deals only with minerals other than petroleum. At present, both are dealt with under the Mines and Minerals, my lord, that is the old act. Then, my lord, your lordships can skip, my lord, nothing would turn. Come to, my lord, the preamble. An act to provide for what, my lord? Development and regulation of mines and minerals under the control of the union. So the act provides that the entire act take within its control the development and regulation. Whatever is necessary for development and regulation of mine is now under our control. Your ladyship is right. Section 2 says to the extent below. I am conscious of it. 2. Declaration as to expediency of the union control. It is hereby declared that it is expedient in public interest, to borrow, my lord, expression from entry 54, that union should take under its control the regulation of mines and the development of minerals to the extent hereinafter provided. Now, my lord, it provides for three things.
Yes.
Lord, first is reconnaissance. Lord, I want to, Lord, show that entire universe, so far as mineral regulation and development is concerned, is now covered by this, and therefore there is an occupied field. Lord, reconnaissance would mean without touching the soil by, Lord, satellite imaging or whatever, one would first decide whether there is any mineral in the land. Second would be prospecting of mineral. So there is a prospecting license regime where you excavate just to find out whether there is any mineral. Sometimes you are trying to find out a mineral and you find B mineral. There is a provision made. Then you have to surrender your lease and give it to the government back if, my lord, instead of uranium, my lord, something else is found. And third is actual mining. All these three. There are two separate chapters under the Act, one dealing with regulation of mines and another dealing with development of mines. And my respectful submission would be that these two chapters, read with other provisions, Lord, I've started with the act, my lord. Can I start after lunch, my lord? It's 5 minutes.
Oh.
So that in one continuity, my lord, your lordship can be.
How long would you now take, Mr. Solicitor?
Lord, one more session, less than that, my lord. But I'll,
You have given 1 day for everybody to conclude, actually.
my lord, we have relied upon your lordship's kindness.
All right.
And
But I think
there is a
everybody should
rule of estoppel.
Everybody should conclude by lunch tomorrow. I think that will be a very fair, isn't it? By
Lord,
lunch tomorrow, everybody
Lord,
now.
we rely.
By tomorrow.
By tomorrow. We have to close tomorrow
Lord.
because we have regular.
Lord, I would say something. Lord, we are before a 9 judges bench. Any lacuna on our part in assistance, Lord, एक minute. Even for the other side, Lord, I would request that if there are 2 counsels, let both give the.
And one more thing, I am going to be doing without prejudice alternative arguments. Your lordship accepts these arguments, the matter ends.
But your
Lordship doesn't
Lord,
accept.
your lordships would,
Not going
Lord,
to
Lord, what your lordships would, my Lord, give it to
After
me.
now, the Solicitor General concludes. I think everybody can take 20 minutes each, and then.
Lord,
because it's
Lord, I would invoke, Lord, I
more of a
would,
good thing now, I think.
Lord, I would invoke the doctrine of legitimate expectation and estoppel. Your lordships cannot cease to be kind. But kindly, my lord, take entry 50, my lord, for a minute, my lords. During, my lord, lunch hours, something, my lord, to assist your lordships and answering the query, my lord, very pertinent questions your lordships have put. Lord, this is my respectful submission, para 50, entry 50. Taxes on mineral rights subject to any limitations imposed by Parliament. Now, this is, my lord, kindly mark. By law relating to mineral development. My lord, what possibly we are reading right now is under a law relating to mineral development. We are searching for a specific section in a law relating to mineral development. In this context, please read it again, my lord. Taxes on mineral rights subject to any limitations imposed by Parliament by law relating to mineral development. There is a law relating to mineral development. Lord, there would not be any negatively worded section prohibiting another legislature from taxing.
The words relating to mineral development, do they qualify limitations or law?
Law, my lords,
Right.
made by Parliament by law relating to mineral development.
Right.
So limitation will have to be found in the law, not, my lord,
Correct.
limitation imposed by a section of the law.
No, but it has to be a limitation in the law.
Correct, my lords.
Limitation has to
And
be read in
therefore-
law.
No, not
Exactly.
in the
Therefore,
law.
and-
Not in the law. That's where, my lord, I think, my lord, the other side is wrong.
By law.
Limitation
by Parliament, by law.
by law.
So
Lord, what we
two
are
things.
reading is
Who
in
should impose the limitations? Parliament. The source should be Parliament.
correct.
What is the source to be found in the law? And what is the law, content of the law relating to mineral development?
Kindly, my lord, now, my lord, kindly read the way they would like it to be read, my lord. According to my understanding, imposed by Parliament in law relating to mineral development. We have a law relating to mineral development. In that law, where is the limitation? I mean, which section provides for limitation?
So
That's
basically,
there.
it's three things: who, how, and in what methodology, or who, how, and about what. Who, by Parliament. How, by law. About what? Law relating to mineral development.
I am grateful, but not in law. That you have a law relating to mineral development. What is that in law? In
But-
that law,
No, but that law must really authorize, that law must impose limitations.
correct, my lords, but not from a particular section which we are trying to find
So
out.
that's the argument, that even if there is no specific limitation,
Yes,
the overall lay of the law, so to speak,
Architecture
the overall
will have to be
architecture of the law, that has been argued. That's the point, really.
that's-
that-
Lord, another
And-
thing, my lord, before I take your lordships to the act.
And you go one step further, you are saying occupied field. Therefore, even if I don't impose any limitations, I occupy the whole field of limitations.
Lord, which
I don't
will-
think that you are
no, Lord,
arguing.
which I
also.
will show to your lordships that anything and everything concerning mineral regulation and mineral development
It's an occupied field.
is taken into consideration by the Parliament by this law made for development and regulation of minerals. That's my respectful submission.
Now let's see the provision.
Before that, my lord, only one answer. Lord, your lordships, a very pertinent, my lord, example of, say, electricity, that some state may enhance the rates of, enhance the duty on electricity or levy on electricity. Lord, I could not answer on that, Lord, immediately, but thereafter I thought about it. Lord, if one particular state increases, my lord, the levy on electricity and the electricity is, my lord, costlier, only that state will suffer. But if the coal meets with the same treatment, the coal is required throughout the country for generation of electricity. Other states will suffer. That is the distinction between, my lord, minerals and others. Coal, coal is just an example because your lordships, my lord, were pleased to give electricity. But any mineral, if I overprice it in my state, the entire state suffers. Entire country suffers. That's a question of federal balance, my lord. And that is how, my lord, your lordships would read an entry, my lord, that serves federal balance, public interest, vis-a-vis the global phenomenon. My lord, now kindly see, my lord, the mineral...
Just since we this statute over and over again. Just tell us now which are the provisions of the statute which you want to emphasize.
Yes, my lord, section 2 I have read, my lords. Please see, my lord, the title of section 4, the main my lord, chapter title, not the section title. Your lordships may have it in page 5, my lord, if possibly we have the same. Page 5. Your lordships have, my lords?
Yes.
Here it. General restrictions on undertaking prospecting and mining operations. This chapter deal with restrictions. Correct, my lord?
Yes.
Now, 4 is prospecting or mining operations to be under license or lease. It is covered by the Central Act. You cannot do it. No person shall undertake any reconnaissance,
Right.
prospective.
That's okay. We need not read it. Just the
Yes. Lord, now kindly see in this chapter, section 9. Lord, the way my lord's queries were, my lord, in the pre-lunch session, my lordships may say that they may consider, my lord, may say that there is no restriction. 9 is an enabling provision that you provide for the rates of royalty, but there is no restriction. But my lord, my respectful submission is, Lord, there would not be any parliamentary law which would prohibit statute, my lord, prohibit an otherwise competent state legislature from legislating. One has to read from the entries only. If Parliament in the total architecture, my lord, fine. What is the total architecture? And then I'll come to only 2 sections. The total architecture is mines and minerals. There are 2 types, major minerals and minor minerals.
yeah.
Minor minerals are localized products used locally. Its impact is not felt outside the state. The act by statutory enactment leaves it to the state to govern it. Lord, kindly, my lord, allow me to repeat this because this is the heart of my submission. The mineral which has no impact outside the state, like mineral, sand, etc., there are no limitations imposed by this act. In fact, there is a permissive statutory provision that you decide how to deal with it. You grant the lease, you decide how the royalty, the rate of royalty also will be fixed by the state. That is permissive statutory provision for minor minerals. And it is done by the Parliament by the law relating to mineral development. Lord, kindly see the distinction. That power conferred upon the state government regarding minor minerals is not because of section 50, entry 50 or entry 23. I'm sorry, my lord.
Yes.
Lord, the power which is conferred upon the states for mineral minerals,
Yes.
Lord, their source is not entry 23 or entry 25. This act, my lord, which is, my lord, passed under entry 54, delegates that or leaves it open to them. That for minor minerals, you deal with it. This act will not deal with it. Lord, now after 2 categories of minerals, so far as...
But minor minerals will fall within entry 23 of list 2.
Pardon?
Entry 23 of list 2.
I'm saying something else. I'm saying something else.
Minor minerals, because entry 23 is subject to entry 50. And the law made by Parliament.
Your lordships are right.
That the state shall regulate.
What I'm saying.
It allows the states to regulate. I mean, conceivably, we are not.
No, I'm saying something slightly different, Lord. I'm sorry, I was not clear. Lord, out of the 2 categories of mineral, what the Central Act sought to, Lord, deal with all aspects is major minerals and not minor minerals, because minor minerals do not have any intrastate implication.
Right.
And Parliament chose not to occupy the field of minor minerals.
Right.
Kindly see section 15. Lord, what I am submitting is, my lord, I am sorry, my lord, before your lordship read section 50. My lord, what I am respectfully submitting, before your lordship sees section 15. My lord, kindly, my lord, allow me to preface this argument. Section entry 23 permits the state government to make the law. Correct, my lords?
Yes.
Entry 50 permits the state government and state legislature to make the law regarding taxation subject to this. Now, my lord, please see 15.
Entry 23 is.
Yes. Power of state government to make rules in respect of minor minerals. The state government may, by notification in the official gazette, make rules for regulating the grant of quarry leases, mining leases, or other mineral concessions in respect of minor minerals and for purposes connected therewith. And, my lord, in particular, my lord, please see 1AG. Fixing and collection of rent, royalty, fees, dead rent, fines, etc., etc. My lord, the respectful submission which I made was
Yes.
the field of minerals, both major and minor, is occupied by this act, but by section 15, this act delegates the powers of minor minerals to the state.
Right.
Now, if we see the architecture and, I'm sorry,
Yes.
architecture and structure of the MMRDA. Lord, if the central government wants to provide for everything concerning major minerals, Lord, what would be the consideration? What are the factors the state government will have to statutorily provide for? A, all kinds of licenses, reconnaissance, prospecting, actual mining, royalty, etc., etc. Lord, every field is occupied by this act, which is, my lord, undisputably, my lord, an act under 54.
So the field of regulation and development is occupied by this act.
Yes. Now, my lord, may kindly come to, my lord, section 13, but the title of section 13.
Regulation and development is.
Please come to section 13. One thing, my lord, I concede your ladyship is right to the extent. My lord, that's my lord, even if it is not mentioned, the limitation will have to be to the extent of the scheme, according to me. And as per, my lord, other side, one section should be there that you are prohibited. That's the difference. My lord, my lord, kindly see the title before, title under which section 13 is placed. Rules for regulating the grants of prospecting licenses and mining leases. This is how the regulation takes place under the scheme of the Act. And please see 13, my lord. Power of central government to make rules in respect of minerals. The central government may, by notification in the official gazette, make rules for regulating the grant of mineral concession in respect of minerals and for purposes connected therewith. Please see, my lord, E, F, and I. E. Utilization of coal or lignite, including mining for sale by a company, the authority by which mineral concession in respect of the land in which the mineral waste in the government. But straight away, my lord, come to I. fixing and collection of fees for mineral concession, surface rent. Please, my lord, note this surface rent. It's a separate category and therefore it can't be a tax on land. Surface rent, security deposit, fines, other fees or charges, and the time within which the manner in which the dead rent or royalty shall be payable. This is all which is leviable and payable. Because the Act takes care of every aspect of major mineral. Well, that's my respectful submission. Now, please come to, my lord, 18.
But, this will apply to all categories of minerals.
No,
Why?
no, my lord, for minor minerals, all major minerals, yes.
That's right.
Yes,
It
yes,
applies to all minerals.
Yes, yes, yes.
All minerals.
Except
In
minor.
fact, chapter 2 also applies to all minerals.
Yes,
Only rule-making power is left to the state government under Rule 15.
No. I'm sorry. ma'am.
Rule-making power in respect of minor minerals is left to the state government.
For minor minerals, yes, yes.
But all other provisions apply to both the categories of minerals. They apply
Correct,
generally to all
correct.
minerals.
But
Because I was just looking at the
but
definition of
30
the expression minerals.
All minerals.
It covers all minerals. Minerals includes all minerals.
correct, my lord.
Except mineral oils. So it's not that minerals includes all minerals except minor minerals.
I'll invite
Minerals includes all minerals.
all minerals, my lord. But for rule-making power,
State can make rules under section 15.
for minor minerals.
Minor minerals.
But
Not only-
13
Not only
is-
that, under section 14, it categorically says. that
Exactly, I was
section
coming to
5
14, I'm obliged.
It's not, they do not apply to minor
Only
minerals.
4
Yes.
applies. Only 4
The
applies.
provisions of section 5 to 13 shall not apply to quarry leases, mining leases, or other mineral concession in respect of minor minerals. These sections are not applicable.
4 is applicable.
And
4 is applicable.
yes, four is applicable. But the rules will be made, who will grant lease, how to grant lease, what will be the royalty, what will be the fee. But my lord, according to my respectful submission, 13I is an all-inclusive provision which can be subjected to levy. My lord, it can be fixing and collection of fees for mineral concession, surface rent, security deposit, fines, other fees or charges, and the time within which the manner in which the dead rent or royalty shall be payable. This is a statutory provision to be made by the central government in exercise of its statutory rule-making power. Now, please come to 18. I'll just show the title, my lord.
And only one thing, if you go to section 15,
Yes, my lord.
similar power is conferred on the state also, rule-making power.
Correct, my lord, for minor minerals. No.
For royalty, etc. also.
Yes, my lord. Correct, my lord. So for my lord, that's what I was submitting. The legislature was dealing with two categories of minerals.
So, therefore, if you see clause number G, it authorizes state to frame rules for even collection of royalty.
Correct, my lord, it's correct. But for minor minerals,
For minor.
For minor minerals, yes, but
No,
that power is conferred.
my lord, I'm saying the same thing, my lord, that there are two minerals, major and minor. For major, the center retain its control. For minor, it is delegated to states except these 5 sections under section 40.
I'm trying to tell you.
So, my lord, these rules for minor minerals, the parliament acquires and then delegates to the state. That's all I am saying. Major minerals, only central government and only I. These are the entries, my lord, it closes. It's, my lord, all inclusive entry. That this is all you can provide for and you can charge. Now, your lordships may kindly come to 18, just, my lord, the title, Development of Minerals.
How do we reconcile your argument with the debates in the Constitution Assembly? When they decided that it should be kept, this power of taxation should be kept with the states?
No, not really. My lord. I have the debates also, my lord, in my note.
that it should be brought in the union list.
Yes.
They specifically said that it should be kept in the state.
Yes, but subject to, my lord, union prohibiting it. Correct, my
But
lord. I am not
no, by your argument, this particular act, this is the only act, Parliament, this is the only act.
Yes,
right?
yes.
Now, this act, it talks about very many things. And in case of minor minerals, it talks about what is being given, so far as minor minerals concerned, the power to the state. It could have also said that the power of taxation for minor minerals is given. It's not said so.
Maybe that is derived from 50.
We have to see why it is not said so. The Parliament.
50, because of 50. They would tax under 50 because.
So therefore, the power to tax.
Allow me to answer. No, my lord. Allow me to answer. That exactly, my lord. That's, my lord. I think your lordships are suggesting my point inadvertently, my lord. Though.
No, you are smart enough to take my point, not differently.
My lord, 50 says power of taxation subject to the limitation imposed by Parliament by law. Now, this is the law. Now, that limitation is lifted for minor minerals. There is no, it can tax, my lord, for minor minerals.
So therefore, your argument is power of the state to levy taxes on operations regarding minor minerals is there.
Correct.
That power is not taken away.
Disputing that. It's
So-
nobody's case, my lord, that they don't have, and I'm saying that no, I mean, they say that we have, and
So therefore,
we are on major minerals.
so states can levy taxes.
Of course, my lord, unless, my lord, it is prohibited. It is not prohibited. Tomorrow, Parliament can even prohibit. Logic, I mean, legally speaking. Not that
Why
it
can't this
will.
logic apply even to major minerals?
Pardon, miss?
Why can't this logic apply even to major minerals?
Lord, I am.
Then there is no distinction between the two.
Yes.
If your stand of the government of India
Lord,
is that
your lordships may not ask me that question. Lord, the answer is very simple. The entire act controls major mineral and keeps minor mineral out of it.
no.
Yes.
Section 4 is applicable to minor minerals also.
Correct, my lord. So, for the, what is section 4, my lord? What is
It
section?
says that without license or a lease, there can't be any mining operation.
Correct, my lords. And, my lord, kindly see, my lord, for 15, that what should be the nature of the lease, etc., the state will decide.
Yes, sir.
Yes, my lord, state. Your lordships, my lord, understood. I hope understood that, my lord, my proposition that 4 provides that without lease and license, you will not, my lord. Kindly allow me to read, your lordships, my lord. Said that I may not read. I'll just read first section. Section 4. 1. No person shall undertake any reconnaissance, prospecting, or mining operations in any area except under and in accordance with the terms and conditions of a reconnaissance permit or prospecting license, or as the case may be of a mining lease granted under this act or the rules made thereunder. Now, this rule making power for minor mineral is 15 months.
Yes.
It's delegated power. That's all I'm saying. Now, my lord, please come to 25. Yes. meaning or charges under that. To 18 title. Section 18 title. development of minerals. Your Lordships have seen first chapter, regulation of minerals, now development of minerals. Only section 18 I read. It shall be the duty of the central government to take all such steps as may be necessary for the conservation and systematic development of minerals in India. My power to fix uniform royalty flows from this. Systematic development of minerals in India and for the protection of environment by preventing or controlling any pollution which may be caused by prospecting or mining operations, and for such purposes the central government may, by notification in the official gazette, make such rules as it may think fit. Well, then there are rule-making powers. Correct? Now please come to 25. Now I may read it closely, my lord. A little slowly, my lord. Recovery of certain sums as arrears of land revenue. Any rent, royalty, tax, or other sum due to the government under this act. Please mark the word under this act. The center has no taxing power under 54. So far as mines and minerals are concerned, state has no taxing power. It can be traced only under 97. This is a future contingency. If for some reason in future it is required to invoke 97, that is residuary entry, for the purpose of taxing mineral, because it is under this act. Initially the reaction would be that tax means tax imposed by the state government. No, it is tax imposed under this act. The rent, royalty, tax, fee or other sum due to the government under this act or the rules made thereunder or under the terms and conditions of any mineral concession may, on a certification of such officer as may be specified by the state government in this behalf by general or special order, be recovered in the same manner as in the land revenue. Lord, it provides whose taxation is the subject matter. The tax may be imposed under this act. And who will exercise the powers? Revenue officer. Why and whom? At whose behest? The state government. Because state in any case collects the royalty. There is no dispute about that fact. So, my lord, this again, my lord, show that tax, if at all, or royalty, etc., my lord, is the subject with, my lord, the central government. Now, your lordships may kindly come to mineral concession rules. So please come to Rule 31. No, page number is same. Maybe at page 65. Lord, I did not say, my lord, law relating to mineral development would include statutory law, including delegated legislation. The rules also, my lord, would be law for the purpose of, my lord, that entry. Please, my lord, your ladyship may see Rule 31. Now, my lord, after, my lord, showing the architecture, I am, my lord, trying to take your lordships closer to something very specific, my lord. 31. Lease to be executed within 6 months, where on an application for the grant of a mining lease, an order has been made for the grant of such lease, a lease deed in Form K. Please mark this, my lord. My lord, Form K, my lord, is very, very crucial to answer your lordship's question, my lord, where it is all inclusive. Form K, or in a form as near thereto as circumstances of each case may require, shall be executed within 6 months of the order or within such further period. We are not concerned, my lord. If it doesn't not, then it lapses, my lord. We are not concerned. Now, please come to, my lord, Form K. I don't think, my lord, in my respectful submission, there can be anything clearer than this, my lord, now Form K. Which, my lord, some part Mr. Salve had shown, my lord, but I am showing something else other than what was shown, my lord. So this is also a part of the statutory scheme. This is a statutory form annexed to a statutory rule, which is a part of the law made for mineral development and regulation under entry 54. My lord, please come to page 122, my lord, possibly.
Yes.
In your lordship.
Which part of Form K?
K, Form K, my lords.
122.
Mineral concession rules, Form K. If we have the same, my lord,
Yes, page 122.
122. Lord, first is Lord, names of the parties. The state would give and the party would. Please come to the second recital, witnesseth. The lordships are with me, my lords. My lord, the Chief Justice are with me.
Yes.
Witnesseth that, now please note, in consideration of rent and royalties, covenants and agreements by and in these presents, and the schedule hereunder written, reserved and contained, and on the part of the lessee or lessees to be paid, observed and performed, the state government, with the approval of the central government, hereby grants the demised unto Lismer. What is the consideration? The rents and royalties. Further, Lord, please see the recital thereafter, my lord. But first 5 lines can be, my lord, your lordships can skip, except, my lord, there is one capital except. My lord Justice Padiwala gets one. Except and reserving out of this demise unto the state government the liberties, powers, and privileges mentioned in part 4 of the said schedule to hold the premises hereby granted and demised unto the lessee so and so years, thence next ensuing yielding and paying therefrom unto the state government the several rents and royalties mentioned in part 5 of the said schedule at the respective times therein specified subject to provisions contained in part 6 of the said schedule, and the lessee is hereby covenant with the state government as in part 7 of the said schedule is expressed. My lord, part 5, 6 and 7 does not provide for anything other than, my lord, what the lease deed stipulates, which is what section 13I stipulates. Correct, my lords? Now, kindly, my lord, turn over the page. Liberties, powers, and privileges to be exercised and enjoyed by the lessees, subject to the restrictions and conditions in part 3. Lord, nothing, my lord, turns on that. Kindly come to page 127, part 5. Yes, my lord, part 4. Liberties, powers, and privileges reserved to the state government. Does your lordship, my lord justice? This is all that is reserved. It doesn't contain, my lord, any other power. My lord, this is the law relating to mineral development and regulation, and I am reading this as a limitation because my submission is it will have to be carved out of the total architecture and not one particular provision. Then your lordships may see part 5. I am not reading entire part 4 because except this, there is nothing left with the state government. They can enter, etc., etc., etc. Then rents and royalties reserved by this lease. The lordship says, my lord, part 5. To pay dead rent or royalty, whichever is higher, the lessee shall pay for every year except the first year of the lease dead rent as specified in clause 2 of this part, provided that where the holder of such mining lease becomes liable under section 9 to pay royalty for any mineral removed or consumed by him or by his agent, manager, employee, contractor, or sublessee from the leased area, he shall be liable to pay either such royalty or the dead rent in respect of that area. Then, my lord, rate and mode of payment of dead rent, then rate and mode of payment of royalty. Please see, my lord, 3. subject to the provisions of clause 1 of this part, the lessee or lessees shall, during subsistence of the lease, pay to the state government at such times and in such manner as the state government may prescribe, royalty in respect of any mineral or minerals removed by him or them from the leased area at the rate for the time being specified in the second schedule to the mines and mineral segment. It does not say that any other taxes, fees, etc., levied by somebody else is covenanted to be paid. Then, 4, the lessee or lessees shall pay rent. So there is a specific inclusion, which according to me also means specific exclusion of anything else other than specific inclusion. The lessee or lessees shall pay rent and water rate to the state government in respect of all parts of the surface of the said lands, which shall form from time to time be occupied or used by the lessee or lessees under the authority of these presents at the rate of so and so. Now kindly see, my lord, most important is part 7, the covenants of the lessee or lessees. Lease to pay rents and royalties, taxes, etc. Look, this is very, very important. This would perhaps, my lord, answer your lordship's question and may, my lord, buttress my submission that whatever is payable, contemplated to be payable and not limited is, my lord, provided in this, my lord. Clause 1 of part 7. The lessees shall pay the rent, water rate and royalties reserved by these lease at such times and in manner provided in part 5 and 6 of these presents, and shall also pay and discharge, please see, my lord, all taxes, rates, assessment and impositions whatsoever being in the nature of public demands, which shall from time to time be charged. So public demands, my lord, kindly underline, assessed by the authority of the central and state governments upon or in respect of premises and works of the lease or lessees. Property tax, revenue, public demands on the premises. That's the only tax or rate or fee, my lord, which is permitted.
It doesn't say so.
My lord, public demands will have to be read with in respect of premises and works of the lessee in common, my lord, kindly further, with other premises and works of a like nature except demand for land revenue. If my neighbor is paying property tax, I am under an obligation to pay property tax only. The only levy outside section 13I are these levies. And this, in my respectful submission, is limitation under clause 50, under entry 50. But only last page 135, the covenants of the state government. The lessee, Lord, your lordship gets me. The lessee or lessees paying the rent, water rate and royalties hereby reserved and observing and performing all the covenants and agreements herein contained and on the part of the lessee or lessees to be observed and performed shall and may quietly hold and enjoy the rights and premises hereby demised for and during the term, etc., etc. This is all that he is supposed to pay. This can be amended by the act, by the central government, and my lord, liberty can be given or limitation can be lifted. My lord, I'll put it that way. Lord, now in this context, Lords, three debates. Page.
Solicitor General do have a lip reader also?
No,
Don't have it.
I think, my lord, this is working, my lord, properly.
Oh my God. All the effort to say things silently.
No, my lord. Your lordships were not heard. I was asking my learned friend, this is a secret, my lord, I am divulging, what Justice so-and-so is thinking. And your lordships asked me the question. So I thought that this is loud.
No, not that.
Mr. Solicitor, a form in a statute can't really override either the statute or can it furnish an interpretation of a constitutional entry. The classical statement was, by Justice Chinnappa Reddy in LIC versus Escorts, where the statutory form was shown to the court and say that, look, this is what permission means. It means prior permission. Justice Chinnappa Reddy put it very well. He says it was always said by a judge of the Andhra High Court in those days that it is the dog which wags the tail and not the tail that wags the dog.
Yes, your lordships are right. No, that's, my lord, if the form is the only argument I have, my lord, possibly, my lord.
A very beautiful extract in LIC versus Escorts on how to construe a statutory form.
My lord, if form is the only argument I have,
Supreme Court.
but possibly,
Code 1369.
my lord, the form I am reading with section 13I. Section 13I says that you can make rules for A, B, C, D, E. What they want to levy is F, G, H, I. That's, my lord, that's the statute. My lord, 13I is obviously a statute, rule-making power, and the form is not, my lord, just form used administratively by the government. It is a statutory form. It has its statutory origin. Now, my lord, I'll read only 3 or 4 paragraphs of Justice Sinha's dissent in Kesoram.
The Constitution.
It is a dissent, my lord. And my lord, apropos my lord Justice Roy's query, Lord, I'll read one paragraph. It's in my written submissions. The Constituent Assembly debates on this. Possibly my reading is, my lord, otherwise, subject to, my lord, being correct. I have examined that. My lord, please come to volume 5, Kesoram, my lord, page 2211.
Volume
5, Kesoram dissent. Justice S.B. Sinha's dissent, my lord. Page 2211. PDF page 2211. Para 410. Does your lordship get, my lord?
It's 202, I think.
Lord, it's 2211, my lords. It starts at 2020, my lord. I am at 2211. I am reading, my lord, relevant paras only, my lord, so that I may not exceed my time. I am already, I know, my lord, testing the, not patience, my lord, but the goodness of your lordship.
what para, Mr. Solicitor?
410. There are only, my lord, then few passages from 2 judgments and, my lord, para 410. The expression any limitations in entry 50 of list 2 should not be given a restricted meaning as contended by the appellant. In fact, the rule of interpretation that the language of entry should be given widest scope should equally apply to the interpretation of the said words. So read, the limitations on taxes on mineral rights could be in any form, including occupying the entire field of legislation under entry 50 of list 2 by a parliamentary legislation and providing for levy of taxes. The MMRD Act precisely achieves the said objectives by occupying the entire field of legislation covered by both entry 23 and 50 of list 2. Lord, thereafter, my lord, Orissa cement is cited. Just, my lord, last line, my lord. I may read the whole. Section 25 implicitly authorizes the levy of rent, royalty, taxes, and fees under the Act and the rules. The scope of powers thus conferred is very wide. Read as a whole, the purpose of union control envisaged by entry 54 of the MMRDA is to provide for proper development of mines and mineral areas and also to bring about uniformity all over the country in regard to the minerals specified in Schedule 1 in the matter of royalties and consequently the prices. Lord, there is a view taken by your lordships
Regard to royalty.
that this is a consideration while interpreting the entries also. Then 412, my lords. This objective would be totally defeated by the impugned levy of cess on coal that has resulted in coal produced in the state of West Bengal totally unremunerative and incompetitive. The price of coal so producing being much higher than the price of coal produced in the adjoining state of Bihar, UP, Odisha, MP and Maharashtra as shown in the comparative chart below. The lordships may please ignore that chart. Lord, 413. The difference in the ultimate price of coal in the state of West Bengal and other states would thus be around 25% of the base price. The submission of Mr. Dwivedi to the effect that the cess imposed is not excessive, therefore does not appear to be correct. From the aforementioned chart, it is evident that no substantial difference can be culled out so far as the price of coal on dispatch vis-a-vis at the pit head is concerned, inasmuch as by reason of amendment, then the court discusses, then kindly come to page 2180, my lord. Para 258, my lord. On the economic front, the country has to compete with the lead developed countries. Your Lordship gets one. Developed countries. Global competition has reached such a stage that despite adequate production of coal and steel, the same are imported from other countries to India. So this case concerns these two minerals only. Countries to India. In the international market also, the quantum of import is going up as compared to export. The manner in which revenue is collected by the center and distributed to the states falls for consideration by the appropriate constitutional authorities in terms of provisions of the Constitution. It is not correct to say that while interpreting the legislative field, the court in case of conflict would lean in favor of the state, keeping in view the fact that taxes under different heads are collected by the center and a part of revenue is made available to the states from time to time. This court is not concerned as to whether the center consumes the lion's share of the revenue or the same is subject matter of criticism at the hands of state or financial observers. Such an approach would not only run counter to the doctrine of federalism with a strong center, but in the long run would prove to be counterproductive. India is a signatory to various international treaties and covenants, and being a party to WTO and GATT, it is obligated to fulfill its transnational obligations. If for purpose of giving effect to the international treaties, it, in exercise of its powers under Article 253 of the Constitution, had taken over the legislative field occupied by List 2 of the 7th Schedule of the Constitution, no exception thereto can be taken. While doing so, the central government shall give effect to the will of the makers of the Constitution and would not act contrary thereto or inconsistent therewith. The legislative fields of union and the state vary from country to country depending upon the requirement of the situation in which such provisions are made. Although a lot can be said on the subject, keeping in view the fact that our job is confined to interpretation of legislative entries vis-a-vis the parliamentary and legislative acts, it may not be necessary to do so. But suffice it to, however, point out that when such an approach is adopted, we would be more prone to committing errors. We must proceed on the basis that neither the union nor the state is supreme in the Constitution, as both the union and the state will have to trace their power from the provisions of the Constitution. We should treat the subject with caution and circumspection. The interpretative principles, whether leaning in favor of union or the state, may, in certain situations, depend upon the subject matter of legislation, the importance thereof, and its effect and impact within and outside the country. Both minerals and tea deserves more control only by the union, having regard to their importance in the national economy. Then 261. Distribution of taxes by the central government in favor of state government is of no moment in the instant case, as the entire royalty fixed by the central government in terms of 1957 Act is payable to the states. The union government has nothing to do therewith. If the Constitution as a living organ is not interpreted having regard to the intention of the Constitution makers, and in case of conflict in legislative field contained in List 1 and List 2, if an interpretation that leans in favor of the state is adopted without a reference to the subject matter thereon or national interest, the same would be subjected to judicial vagaries which cannot be countenanced. This is all, my lord. My lord, now just, my lord, answering my lord's query, my lord, I'll just show two things, my lord. A, the Constituent Assembly debates. But this is all I want to say now. Constituent Assembly debates. B, parliamentary debates when this MMRD Act was introduced, where it is said that we want to denude the state from its power. And Not some propositions, I have quoted the judgments which I will not read. Because your lordships are, my lord, except two judgments. One is Hind and another, my lord, judgment on the question, what is the meaning of an ambit and the scope of the term regulation? Lord, my respectful submission would be regulation would also include a prohibition against any levy. And there are some judgments on that, my lord. If your lordships, my lord, kindly come to my written submissions, my lord, which is 2F. The Justice Pardiwala had 2E, my lord, kindly ignore 2E, 2F.
Doesn't accept it.
Lord, at page 44, 45, my lord, well, this is my reading, my lord. Your lordship's reading must be right. But let us read, my lord, subject to being corrected. My lord, first discussion is on 52. But that is similarly worded provision that industries which are declared by law to be under the control of the parliament in public interest. Your lordship.
52 of volume 2F.
Yes, my lord. 2F, page 44. For 45, my lord, I'm sorry.
That's the list of dates?
Yes. I'm not going to read, my lord. I have just given the list of dates. I would request your lordships, my lord, to go through it. My lord, the purpose is to show that historically, considering the very nature of minerals, it has always remained in the hands of the federal government earlier and central government thereafter. Lord, your lordships have, Lord, date 31st August 1949, my lords. Right. My lords have them. The entries in the union list, entry 52, 53 and 54 in the, I'm sorry, my lords. Lord, page number 45, 31st August 49. This is Constituent Assembly debates.
Yes.
The entries in the union list, entry 52, 53 and 54 in the final constitution and entries 64, 65 and 66 in the draft constitution were debated in the Constituent Assembly. The relevant portion of the debate is as under. Honorable Dr. Ambedkar, sir, I move that entry 64 of list 1, the following entry be substituted. No, this is 52, present 52. Shri Kamath, Mr. President, I move amendment number so-and-so of third list, sixth list, week, which reads as follows, that in amendment number 35 of list 1, in the proposed entry 64 of list 1, for the words the control, the words development and control be substituted. No, this was not done. Kindly come to the next page. Dr. Ambedkar, my lord. Somewhere in the middle, my lord, your lordships would find.
This control of the industry.
Does your lordship, my lord Justice Roy find? The Honorable Dr. B.R. Ambedkar, sir, the entry as it stands is perfectly all right and carries out the intention that the drafting committee has in mind. My submission is that once the center obtains jurisdiction over any particular industry as provided for in this entry, that industry becomes subject to the jurisdiction of Parliament in all its aspects. But please note, this is entry 52, similarly worded, that industries which are declared by law made by the Parliament to be in public interest. Similar to 54. And this is what, Lord Dr. Ambedkar.
No, there is one difference between the two, entry 52 and entry 54.
Yes.
In entry 52, it is industries, the control of which by the union is declared.
Correct.
But in entry 54, regulation of mines and mineral development to the extent to which such is declared by the Parliament.
To the extent I'm considering.
There is a vital
54
difference.
is vital, wider, please see. Regulation of mines and mineral development to the extent to which such regulation and development under the control of the union is declared. It is in fact wider. But They say that whenever there is a control conferred by an entry,
Yes.
everything falls within that law. That's not my reading of, not mere, kindly see, becomes subject of the jurisdiction of Parliament in all its aspects, not merely development, but it may be in other aspects. Consequently, we have thought that the best thing is
Once the control is declared by the union, to be expedient in the public interest. Therefore, Dr. Ambedkar said that every aspect of control is then subsumed in draft entry 64.
that's all, my lord, I wanted to say. Now, my lord, may only allow me to show when, my lord, this act was enacted.
Here we are dealing with only limitations.
Pardon?
Here we are dealing only with limitations.
Lord.
The entirety of the field, once control is
Again, my lord, at the cost of repetition, I'll not.
then the central government takes over the entire control of the industry.
Yes.
Lord,
And that control will
if we
include
find-
all aspects of control. It's absolute.
certainly. But if we try and find out, my lord, in my respectful submission, it's a wrong question to ask, and therefore we are not getting an answer. That where is that particular limitation? The answer is limitation is put by law, not under the law. By law, the law itself is a limitation. Lord, I have already addressed, my lord. I will not trouble your lordship with that, my lord. Now, please, my lord, in this when your lordships are on this, see, my lord, page 23. Lord, this is Lord, this is parliamentary debate when this MMDRA was introduced in 57.
Where do we get that?
Lord, page 23. Same, Lord, the written submissions, 23. Lord, only underlined part, my lord, I have underlined certain portions, my lord, for the sake of, my lord, saving the time. Lord, K.D. Malaviya, my lord, your lordship would find only the highlighted part. I agree with him that left to ourselves, we should increase the rates of royalty further, but the rates of royalty cannot go beyond a point. When in international competition, the price element becomes somewhat against us, and this is a factor which we cannot ignore. The moment we increase the royalties beyond a point, it will have its own repercussion on the total price factor, and we cannot ignore it. This was the intention to put the entire architecture under the control of the central government. Then this shows that at the time of passing, state governments were urged to look beyond narrow considerations because somebody objected, somebody from the state objected. And two, the legislators were cognizant of the impact of royalty on the prices and consequent impact on international market. My lord, now please come to page 24. My lord, Rajendra Pratap Singh, Bihar. Page 24. 24. 24. Lord, only the highlighted, black highlighted part. What we are doing in this bill is to denude the state of all their powers and responsibilities, not only with respect to the minerals mentioned in Schedule 1, which is very comprehensive, but in some respect, we have even taken away the regulatory powers of the state in respect of all other minerals. So this was the intention behind framing 1957 MMDRA. Lord, that is my respectful submission. Lord, kindly see. Lord, kindly see thereafter Santosh Kumar Basu, West Bengal. Lord, only the highlighted part. At the same time, Sometimes I wish, my lord, the lip reading could have been a course in the 5-year law. But
But when they're choosing jury members, they have people observing the body language of the juries, potential juries. And depending upon how they are sitting, how they are sort of gesturing, they will say, all right, he is a jury to be selected for my part, in my turn.
oh,
Just in a lighter vein, solicitor, if you are privy to all the conversation which is happening here for last 5 days,
I'll be
perhaps
discouraged.
matter would have been over by this time.
That secret keeps us going, my lord. Whether we it is only that secret, my lord, which all of us, my lord, that keeps us going, my lord.
There is still hope.
My lord, that was a very potent word, my lord. Almost, my lord, divulging what my lord justice hoped.
No, what I said applies to Mr. Dwivedi also.
Lord, I'll not, my lord. Kindly, my lord, go through it. Go through, my lord, the entire parliamentary debate. What it says is that we cannot have a narrow state-wise understanding of the royalty regime. Whatever is to be done has to be done holistically, nation-wise, and global-wise. Lord, that was the intent and purpose. Now, my lord, I'll cite, my lord, 2 judgments. Lord, page 62, if your lordship, my lord.
Of volume
Of
5.
the very same. My lord, first is Hindstone. My lord, I would read that, my lord, first. It is 63. My lord. I'm sorry, my lord, page 62. Hindstone is very. One minute, I'll cite the judgment. To page 62, regulation and mineral development and in public interest. My lord, I have cited. I think. Page 62. 62. Regulation, mineral development, and in public interest. My lord, state of Tamil Nadu versus Hindstone, Lord, it is a leading judgment, my lord, followed till date on regulation. My lord, please see only the underline highlighted part. We do not think that regulation has the rigidity of meaning as never to take in prohibition. Much depends on the context in which the expression is used in the statute and the object sought to be achieved by the contemplated legislation. I have shown the object, I have shown, my lord, the context, and my lord, in my respectful submission, regulation of mineral would also include prohibition of any other kind of levy by anyone except what is stipulated in the Act, my lord. Then, my lord, at the foot. This is again, my lord, at case on minerals, my lord, therefore a little closer home. Support by so this. So it's clear.
Yes.
Lord, kindly then come to, my lord, next, Hindstone, which was referred, my lord, in Quarry Owners Association. Quarry Owners Association. Page 63. It's 2 or 3 judgments. Only underlined part, my lord. Only underlined part. The word regulation may have a different meaning in a different context, but considering it in relation to the economic and social activities, including the development and excavation of mines, ecological and environmental factors, including states' contribution in developing, manning and controlling such activities, including parting with its wealth, that is, the minerals, the fixation of rate of royalties would also be included within its meaning. When the law relating to regulation, which is, my lord, the chapter under which, my lord, 4 to 9 fall, my lord, would mean, my lord, this thereafter, my lord, subsequent. So in regulating mineral development, the royalty stock dead rent is the inherent part of it. The state has thus before it, the state means capital S, not the state government. The state has thus before it a number of factors as aforesaid, which would guide it to fix, enhance, or modify the rate of royalty or dead rent payable by a lessee. My lord, similar, my lord, are the judgment, my lord. I am not duplicating, but kindly treat them as read, my lord.
In the name of regulation, can the sovereign function or the sovereign priority to impose a tax be taken away by another sovereign?
If constitution entry permits, yes.
Therefore,
50 permits then.
intentionally, the words uses any limitation. It is not any ban or a total prohibition.
Limitation would also include prohibition. Limitation means I restrict you from doing this, whether by a specific provision, again, my lord, repeating, or by the entire architecture. No, limitation can mean even extinguishment. That I limit you, I restrict you. Limitation doesn't mean that don't charge more than one. Limitation is a very wide term with wide connotation, my lords. Limitation can include, my lord. I am not on this matter. Otherwise also, limitation, I don't think the other side also argues that limitation cannot lead to prohibition. It can lead to prohibition. The prohibition is specific or you have to see the entire architecture? That is the question. Lord, then, my lord, page 67. I'm not reading it. Just hurriedly taking your lordship through. My lord, Hingir Rampur, my lord, reading. I'm not reading it. Mr. Salve has taken your lordship through, my lord, all these judgments till, my lord, page 86. Page 85, my lord, sorry. No, 86, 86. Lord, I am not reading it. This is my interpretation of judgments from Hingir Rampur. Now, my lord, the last but one point, my lord. Entry 14, my lord, I'll just make 2 propositions, my lord, because Dr. Singhvi is arguing on that, my lord, that lend at entry 49. Lord, anyway, my Lord, my learned friend, I'm just, Lord, the argument was that if I do not fall under entry 50, the tax, I can always tax under entry 49. Your Lordships would recall. Well, please see entry 49. Lord, if the argument is true, we will make 50 redundant. That is number one. And number two, when there is a specific entry, general entry can never be resorted to. Lord, please see 50. My Lord, I'm just giving the propositions, my Lord, and not, my Lord, taking your Lordship's time. 50. Taxes on mineral rights subject to any limitations imposed by Parliament by law relating to mineral development. Now, 49 comes if they fail in 50. Their argument is that if we do not have the competence under 50, then we rely upon 49. Please see 49. Taxes on lands and buildings.
I'm sorry to interrupt, but I must clarify, it's not that entry 50 doesn't apply, then 49. It's entry 49, and if that doesn't apply and you say because the measure is minerals, then also it's 50. It's a reverse, not what you are saying.
As I have shown, my Lord, first of all, as I have shown from, my Lord, the subgroup, my Lord, this so-called artificial distinction between measure of royalty, namely in terms of tons or in terms of area, is now blurred. It has always been blurred. For some minerals, it is on tonnage basis. For some minerals, it is on the basis of area. So it doesn't matter, my Lord, whether your mode of taxation is the mineral itself or the land itself. But, my Lord, the land tax on land and buildings is a separate entry, not only separately defined, but the term land would take color from buildings. What it provides for is, my Lord, property rights or something which deals with land, not anything below that. Another thing, my Lord, the very fact that for the purpose of taxing you have entry 50, and for regulating that very product entry 23, and also 54 in list 1, oust, my Lord, 49. This is, my Lord, an argument of desperation, that my last ditch argument, that if I do not fall anywhere, then I'll fall under 49. Well, land and building is completely a different subject. My Lord, there are two Constitution Bench judgments, my Lord. One is, my Lord, at page 87, Waverly Jute Mills Company versus Raman and Company. I'm not reading it.
The citation that you said, page
Yes.
87. Page 87.
It's page 87. The citation is also given. It is, yes, 1963, volume 3, SCR 209. Lord, I would. Lord, I'm sorry. Lord, I'm sorry. I thought, Lord, only, Lord, the proposition it lays down is, Lord, is one judgment and underlined portion at page 88 would be enough, Lord. This is Waverly Jute Mills, Lord. Please see. It follows from this, your Lordship gets, my Lord, underlined portion. My Lord Justice Roy gets.
Yes, yes.
It follows from this that where there are two entries, one general in its character and the other specific, the former must be construed as excluding the latter. This is only an application of general maxim that generalia specialibus non-derogant. It is obvious that if entry 26 is to be construed as comprehending forward contracts, then future markets in entry 48 will be rendered useless. Raised our judgments on the same propositions. Lord, I am not, my Lord, reading, but I would earnestly request your Lordships to just glance through them, Lord. They are really illuminating paragraphs. But, my Lord, it would be unfair, my Lord, on my part, my Lord, too. Now, my Lord, page 91. Nature of royalty. Lord, my respectful submission is very categorical and specific. And I think, my Lord, we are ad idem on this one, both sides, for different reasons. My Lord, royalty is not a tax. Dr. Singhvi may arguendo as an alternative that if suppose if it is a tax. But our case is royalty is not a tax for the simple reason that for tax you do not need any justification. If the government is taxing me, there need not be any justification. But in case of a royalty, the government is parting with its sole privilege over the natural resources and permitting you to exploit it and sell it, and therefore you are paying consideration. It's not a tax, my Lord. These are all judgments, my Lord, which take the view. There are judgments, my Lord. This is the, again, my Lord, occupied field in, my Lord, the lighter vein, my Lord, by the judgments that royalty is not a tax. But, my Lord, I would say,
But in India Cements, the question was tax on royalty.
correct.
Royalty is not a
It was
tax.
cess on royalty.
Cess or tax imposed on royalty.
Correct.
And it was
But my answer is, my Lord, my Lord, I'm couching my statement, my Lord, very accurately. For the purpose of section 9, royalty is not a tax. My Lord, why I say this? Well, there is a reason. Lord, we have filed an affidavit on behalf of Ministry of Petroleum and Natural Gas. For petroleum and natural gas, which are also minerals, there is a separate entry, namely entry 53.
Right.
And there is a separate set of acts. There are 2 acts. There, my Lord, the concerned public sector undertaking is, my Lord, taking a stand that it is a tax, which it can take, my Lord, because entry is different and the statutory scheme is different. But so far as section 9 is concerned, and the architecture of MMDRA is concerned, the royalty on minerals covered by MMDRA is not a tax. Lord, if your Lordship would like to write it down, volume 3G is the affidavit of the MOPNG.
Volume 3G.
Lord, I must say, Lord, initially, both minerals and petroleum, that is called mineral oil, were, my Lord, under the same regime of 48 Act. But thereafter, specifically, my Lord, even the statement of objects and reasons of MMDRA says that now we are having a separate regime. Lord, therefore, we have filed this affidavit so that the PSUs can take a different stand, my Lord, and that may perhaps be a justifiable stand. Lord, these are my respectful submissions, my Lord. My Lord, I have prepared propositions, my Lord. I may, my Lord, revise it and file it by tomorrow, my Lord, so that your Lordship may get, my Lord, what are my legal propositions. It is available. I have also uploaded, but during the course of the hearing, my Lord, I would like to, my Lord, make some changes, my Lord, for your Lordship.
Certain.
My Lord, privilege to assist.
Thank you.
I had also revised a lot of things which in the course of submissions, would your Lordship would may I give a written note of Marat finally as how the matter was presented?
Thanks. We need a note from Mrs. Harvey, I think.
Today,
If you want to, but we have taken very elaborate notes.
Very well. Very well.
Now, let's, well, it's the wait, please, my lords.
Hearing Mr. Dr. Singhi.
Well, as I have a written note, it gives the civil appeals where I am appearing, Kisma and others. The numbers are given there. I'll take your lordship through it. At the outset, let me say this, fellas. The advantage or disadvantage of the 9 judge benches that your lordship, though not on a tabula rasa, are not bound by any landscape. So whatever your lordship does is what is most persuasive or on first principle. So we will cite cases, but they are only intended to be persuasive this way or that way. Neither 7 judges nor 5 judges in the lordship will find some useful reasoning in some cases, which is why we will deal with those cases in that sense. Secondly, almost every argument of mine is without prejudice in the alternative, and assuming that the arguments already made do not succeed, because if they succeed, your lordship doesn't need to reach many of my arguments. And that's the way it should be done, because the 9 judge bench is laying down law for a pretty long time, if ever is going to be reconsidered. And your lordship should have all the perspectives and should deal with them, because it should not really be leaving holes to be discussed again, and then again some new reference comes. Thirdly, your lordship will always keep in mind a general view, a general question which I want to ask again and again. Ultimately, all this is being done, all these exertions are being done because of Kesharam. And my humble and respectful submission is, my question to myself is that there has to be something very special about Kesharam's correctness for your lordships to go in that direction or adopt that view. Because according to me, Kesharam, apart from all that other debate about 5 judges touching on 7 judges, not referring it to 9 judges, but themselves deciding, etc., that is a separate debate. Kesharam, what is so wrong with India Cement? And conversely, what is so special and right about Kesharam? That, if I may use a phrase not irreverently, it sets the cat amongst the pigeons on a certain corpus of law, which has been going on and on. And that question, I believe, is not satisfactorily answered, because Kesharam really does an ipse dixit. Now, I have done this. I have, the other thing about 9 judges, by the time we reach the 3rd or the 4th persons, we have to take our original written submissions and chisel them down, cut off what is covered. So that's what I've done. I've tried to chisel them into 6 propositions, which remain. And they are mostly in the alternative. They are right on the top of my submissions, which your lordship, I'm told, gets at volume 2E, page 305. Give me submissions. Put it here. Mine is not correct. Mine is the old one. I'm going to only stick to those 6 propositions, and everything, including case law, relevant portions are quoted there. So that speed will be assisted. The lordship will not have to spend.
Page 305.
I'm told this volume 2E 305 is been loaded.
Yes.
And as I said, these submissions are not in any manner to detract. They are only to reinforce an alternative view. And I think your lordship should have. So lordship will, in a sense, forget what has gone in the past and now kindly see an alternative view to some extent. The first is, royalty is a tax and or qualifies as an impost and compulsory exaction under 366(28). In my submissions, I've pinpointed the paras dealing with this, B1 to B32, and the pages 21 to 32. So your lordship has exactly where I've dealt with this, with the extracts and the quotations. It just fell, as Mr. Mehta ended, fell from my Lord Justice Naganathan, India Cements. India Cements directly holds it to be a tax. It then says the cess is also a tax, so it's a tax on tax. Para 34. I'll come to it. There's no India Cement or Keshora binding you whether it's 7 or 5. But what is the lordship see the intrinsic worth of the reasoning? It's not wrong. So the first is royalty is a tax and qualifies, and my more concern the second part of the sentence, impost, compulsory exaction, etc., and the test of a constitutional article, not merely a statute. My second submission is, and I don't think enough weight has been given to that. A second very important levy, it may be a little less in quantum term, very important levy, dead rent, is clearly, of course, based on acreage, and being a tax, clearly a tax, is directly occupied by 9A, not 9A. The paras are given B29 to 32, 31 to 32. This tax is a tax on mineral rights. Unlike my fourth argument, which is a little different. This is a tax on mineral rights. The third, of course, although your lordship dealt with it, I'm going to be arguing a little addition here. Entry 97. And the reasoning will go, if I may just summarize the reasoning. Entry 50 itself recognizes a taxing limitation by Parliament. Your lordship is looking at the second part of 50. Your lordship sees the opening word is taxes. The limitation must include limitations of taxation. Has to. Otherwise, the section can't be read properly. The entry can't be read properly. I'm just summarizing my point 3 because I'm developing it later. I'm just summarizing. So, step 1, entry 50 recognizes taxing power of Parliament itself in its own entry. Second, it recognizes a limitation on that taxing entry on itself because of a parliamentary superior taxing right. Third, it then says that therefore, I'll be excluded. It can only be by combined application, because it's tax you're talking about, of 54 read with 97. Because taxing is specifically dealt with in 97. Now my Lord's query, which I'll be dealing with, namely, that 248.2
governs
248.2
otherwise not specified in any of it.
248.2. I said so.
The moment it is specified.
248.2. No, your lordship is really formulating 248.2. That's the query my lords put. 248.2 is otherwise not specified. Entry 50 specifies a taxing limitation itself.
But therefore,
yes,
such a tax has to fall under entry 54. It can't fall
with 97. An entry which has been forgotten, dealt with 3 of your lordship's cases.
It cannot ever fall under entry 97 because it is tax which is specified in one of the lists.
Entry 54 and 97 read conjointly, read with the third factor, a limitation in 50 itself, recognizing the taxing power of Parliament. The 3 things add up to create this proposition. That's why I said this is a little different. I've developed it. This is 3 things, the synergy of 3 things. 50,
but if there is a limitation on the taxing power of the
50.
State, that does not mean that the entire subject is transferred to Parliament to levy a tax.
It is, if Parliament chooses, as it does in section 15, to say, for minor minerals, the state can do it, it is different. Otherwise, it is entirely with Parliament. Parliament chooses not to say it in section 13.
Entire field of levy of tax on mineral rights is with the states. That power is subject to limitations which Parliament may impose by law.
Including, the word limitation starts with a taxing limitation. See the entry. See, I'm going ahead of my own story. Just see the entry. 50 says taxes on so-and-so, including limitations.
Yes.
The primary limitation has to be a taxing limitation. It is dealing with, in fact, 50 is a recognition of parliamentary superiority in taxation, apart from other things.
But in H.S. Dillon, this court has said, if a taxation entry is absent in list 1 or list 2, then it can be in entry.
That's exactly what Mahalakshmi says. That's exactly what 5 judgments of the Lordship says.
But we have all seen from the last 2-3 weeks, we are seeing the taxation entry in entry 50.
Well, with respect, it's that private law example, very loose example, wrong example, but of Renvoi. It's a circle. The Lordship knows Renvoi in private international law. It's a circle. 50 you start with. 50 recognizes the superiority of Parliament, especially in taxation. These last 3 words have been less emphasized. that superiority of parliament in taxation then gets completely coalesced and developed by a conjoint reading of 54 with 97. Because 50 subordinates itself in taxation,
No,
to a parliamentary taxation.
what entry 50 recognizes is that the taxes on mineral rights can be imposed only by the state legislature, since it's in the state list. But while doing so, you are subject to the limitation which Parliament may impose by law. That is not to say that the moment Parliament imposes a limitation, that whole field is then transferred as a taxing power to the union.
That is Mr. Salve's and Mr. Mehta's argument. I'm now doing a totally different, nuanced argument. That first part, Your Lordship, is totally occupied, etc. I'm not derogating that. Well, if they succeed, if Your Lordship will hold this way, that matter ends, well, this way or that way. Now I am saying something in addition. That's why I said this is separate. One is occupation. Really does. That's my, actually the rest of my written submission has those submissions. I'm not giving Your Lordship those submissions at all. My argument is that forget the occupation doctrine. Well, may I do it when I come to the third proposition rather than do it now? If Your Lordship will read the entry itself, I'll develop it from there. Let me just finish the propositions first. So that's my third proposition. And that is dealt with in para 8 to 32, pages 5 to 15. Fourth one, which is corrected one. Now, whereas the fourth proposition is, of course, I must emphasize wholly in the alternative. Your Lordship has been dealing till now with mineral rights. Ask a simple question, Wallace. Regulation and mineral development is the word in 54. If they didn't want the words to be different, why did they use mineral rights in 50? The answer is also answered by Your Lordship. So all these cases have not been given meaning and importance by Wallace Kesharam. And many of them have been noticed, not only Justice Sinha, but in other judgments. Why is it that 50 uses mineral rights, whereas 54 uses, if they wanted to give the entire space, the entire universe, they would have used the same words as 54 in 50. Or they would have used the words of 23 in 50. 23 is a mirror image of 54, which is why Your Lordship has always held denudation. They use mineral rights because it's a very narrow area given. So my fourth submission is, Your Lordship should lay down in this judgment, because we don't come to 9 judges again and again. Lordship doesn't want chaos in the law. The difference between tax on minerals versus tax on mineral rights. The two are different. Your Lordship will only lay down guidelines. The division benches will decide whether the impost in question falls this side or that side. But Your Lordships must lay down guidelines, because, take a simple example, brothers. My lease or license to him of 10 years, 15 years, 100 years can be taxed. That's a tax on mineral rights. It is very different from taxing the quantum of mineral extracted on tonnage or sale. That is conceptually different. The language is different. The advisedly, the Constitution uses different language. Please don't equate tax on minerals with tax on mineral rights. That's my fourth proposition. Well, as my fifth is, well, as the alternative, which is again not been argued. It is a clarification which is important from 9 judges. That today we leave this court, well, as after arguing all this tax this way, tax that way. Tomorrow, well, as the states get up and say that was a case deciding tax. Oh, but I have the power to levy the same thing or similar things on the ground of fee. Now, Your Lordship has held very clearly that if 23 is denuded, then the power eclipsed, not denuded, eclipsed, then the power to levy fees concomitantly in 66 cannot be there, because 66 operates only if the main power is in 23. That's my fifth proposition. That clarification should be clear, that we don't, well, restart the whole litigation on by different names called some fees being levied. If 23 is gone, now why it's important also is Kesharam has a loose paragraph, with great respect I say. So say all fiscal levies. Whether all fiscal levies includes fees or not, Your Lordship should clarify. If there is no 23 power in list 2, there cannot be a 66 power to levy fees. And all states are levying fees relying on that para of Kesharam. 110 to be precise. I'll come to all those details. That's my fifth proposition.
How much of entry 23 list 2 is denuded is the question.
Well, fees can't operate.
No,
If the
NP 23
I agree.
is true.
Identical language of 54 and 23, the denudation must be completed. That what will happen is, I understand my lord's query. This is more the occupation argument. But what will happen is, Parliament, the framers use same language in 54 and 23. Now, unless Parliament passes a law about a coat, a gown, a band, it is then said that the states can tax the pant and the shoes. Unless Parliament has evinced an intention that we will tax only the coat and the gown and the band. And implied in it is Parliament's reticence and hesitation and prohibition on itself not to tax the trousers and the shoes. Your Lordship will not read the entry 23 in a manner that if it is exercised and you, the chair example is limited value, it's a limited value. A lighter vein, Mr. Mehta seems to have taken Chief Justice's advice. He moved me one chair further. He occupied my this chair also. I'm worried that he follows the Lordship's advice too literally. But, the answer to my Lord's very important query is that the occupation is not that your Lordship will then encourage piecemeal legislation by Parliament and say that you are not able to occupy because you intended to occupy. Because the intention of Parliament is that we believe in our wisdom that only the coat and gown must be taxed. But the subject matter is the same, there can't be a dispute. In entry 60 is one advantage I have subject to your Lordship's kind discretion. 66 is entirely dependent on 23. Now 23 and 54 fortunately have identical or virtually identical language. Then the denudation will not operate. In my coat and trousers example, on only how far the taxation is gone. Then it will not. That's my submission. And the last one, is very interesting. I made a self-contained note, which I may not read. It's about 9 pages. It gives 10 fundamental reasons. 3 of them why there is no typo in India Cements as found by Kesharam. And 7 other patent errors of Kesharam. You'll also will see only two lines of that. I will read out of those 10 pages about 1 page, 1.5 pages. For example, Kesharam says that India Cements cites 2 High Court judgments, but does not follow 4 other High Courts the other way. And therefore, India Cements is wrong. Actually, what India Cements does is, it cites those 2, it cites the other 4, and says we prefer these 2. A point which Kesharam completely misses, or in fact overlooks.
All right, Dr.
Let's now start one by one.
We are just almost at 5 to 4 now.
Tomorrow.
We'll continue tomorrow.
I will finish well in time. Mr. Ganguly will get enough time.
Who follows Dr. Singhvi now?
Mr. Kambata.
Lord, I would, if your Lordships permit, Lord, I would like to address for about an hour or so, if your Lordships permit me.
So, Mr. Kambata, Singhvi, then Mr.
After me, Mr. Ganguly is there.
Mr. Ganguly will argue. Mr. Bagaria.
No, I take 15 minutes. Not there's a referral order.
We just want to put you.
Tomorrow,
everyone has to finish by lunch. Dr. Singhvi will give you 10:30 to
3 o'clock. Make it. Mr. Dwivedi will get the full of Thursday and some part of tomorrow also.
Dr. Singhvi, what we'll do is this: we'll give you 10:30 to 11:15. We'll give Mr. Ganguly 11:15 to 11:45. Mr. Bagaria 11:45 to 12:15. Mr. Kambata, 12:15 to 1:45, and 15 minutes for you.
Well,
that's
only
it.
one thing. Everybody
else,
5 minutes. Your Lordship has seen the nature. Allow me at least 1 hour, it won't be fair otherwise on the submissions.
I was wanting 10 minutes, Manoj.
In Dalmia Cement, the order by a 3-judge bench, where they referred 6 questions and directed it to be tagged along with this. Now, my lord, my submission is I'm going to request your Lordship. Those out of the 6, only 1 relates to nature of royalty. The remaining 5 can be kept separately. Subsoil right, who owns the minerals, etc. So I've made a PowerPoint presentation, and I'll just take 8 to 10 minutes. About 6 slides I have to show your Lordship. Your Lordship.
So you want that to be detagged with?
I have to make
except on royalty.
On the royalty issue. Remaining, I'm not submitting. And to save time, I made a
I think that should be detagged, Manoj. That should be detagged.
No. I have a similar request.
The subsoil can be
ONGC and other.
ONGC also got detagged, yeah.
ONGC, oil,
So you can tell us which are the matters to be detagged. I think on this there should be no dispute. Mr. Dwivedi, Mr. Datar, and the Learned Solicitor General, please give the courtmaster by tomorrow morning the list of matters which are to be detagged.
Yes.
Mr. Datar, we will detag your matter as well, on royalty, since we have heard arguments on what is the nature of royalty,
I'd
we
only
can take a
submit
small
on entry
note.
50. I've just submitted on entry 50 as to what is this. Lord, I've made this submission, Lord. I've said that the levy, entry 50 talks of tax on mineral rights. Tax has three components: levy, assessment, collection. Levy is taken away by 9A 90. So I've made a chart. So only levy is taken.
Give us the chart.
Lordship may just.
But we have given you the bottom. 1 second. We have given you the bottom line. All learned counsel have to put their heads together so that you finish by lunch tomorrow. Absolutely no question of going ad nauseum. We will never finish otherwise. This will go on to next week and we have another matter next week.
May I just say one thing?
The other submission we have made in the context of mining lease. Lord, mining lease is normally for a particular area, 20 square kilometers, 40 square kilometers. So we have drawn a map. Tamil Nadu's goal is entry 49.
All right, we'll delink your matter, Mr. Das.
No. Mine only on royalty.
It should be
royalty. Mining lease is only entry 50. The mining lease.
Royalty, we'll hear you in 5. We'll give you 5 minutes to hear your arguments on royalty. We have heard.
This is going to be done at some moment. We will not be able to do justice.
My lords, I just wanted.
I'll cut 1 hour from my argument. Allow me till 11:45. Mr.
Dr.
Dr.
Singh, we have no difficulty. We have no difficulty. Anybody who feels that, everybody has to decide now that, who's going to take how much time?
15, I'll finish by 11.
But no difficulty. So
My lords, I was.
I'll attempt to complete in half an hour. Till 4 o'clock.
This side will know. Sorry, we'll not do that.
Written submission.
My lords, I was wanting 5 minutes.
Whoever remains written submissions, Mr. Dwivedi, you start at 2 o'clock and you conclude at 4 o'clock.
My lords, maybe we have 5 minutes, my lords.
I will take. Give us Thursday, fellas. We will not go beyond Thursday, fellas.
Your lordship gave me one day.
My lord,
Your lordship gave me 1 day.
The matter will be, I'll tell Lordship, the consequences are huge, Lordship will not, because it's going to affect all mineral rights.
But adding zeros doesn't change the legal principle. The principle is always the same. Irrespective of the number of zeros or decimal places added.
My lord, please, my lord,
Lordship,
don't Thursday, my lord. Kindly give, I have given 15 minutes, kindly give 5 minutes, my lord. I have counted 32.
Thursday will
It was, my name is there at serial number.
But I was wanting 5
मैं आपको हिंदी में
minutes. my
समझा
lords.
सकता हूँ. आप सब शाम को बैठ लीजिए, तय कर लीजिए. 2 घंटे में, 2.5 घंटे में सुबह आपको सबको तय करना है. आता इस बहस इस तरफ. 2 o'clock, we are putting Mr. Dwivedi in. This will never get over otherwise. Thank you.
Great.
Grateful.